direction upon the trial court for expeditious.
This interim application, Lordship. Interim application. This is relating about minor, Lordship. Custody of the minor, Lordship. Kindly, opposite party is present, Lordship. Not the other way.
If it is not called on, come at 11:45.
Lordship. Grateful.
Item number 1, under for order.
Please, my lords.
No.
Please, Lordship. I'm grateful. I'm sorry. Lordship has taken up item 1, Lordship.
Item number 1.
Yes, Lordship. Lordship, this is that matter. I'm grateful. Just one.
এটা কি ওইটাই যেটা সেই ইয়ে ছিল? Yes.
Yes, Lordship. Lordship, this is that matter which was argued 2-3 days back. This was in relation to the Order 7, Rule 10 that had come to be refused. The invoice being the last understanding, and if that's where the jurisdiction is agreed, that may happen. So, but Lordship posed a query to us that, sir, why did we wait for so long, and does that work against us in that scenario? So I was to satisfy my lords, and whether in the written statement, if I had taken something on that aspect, and if I had not taken something in the written statement at that point of time, does that debar me from putting in a 710 at this stage? So, Lordship, we've done some homework, and if we can assist the Honorable Court, if the local council is present, Chair, sir, the local council is perhaps reaching there, but if my lords may permit us to screen share, we're relying about 5 or 6 judgments, and I'll brief my lords on the points of law that we're relying upon.
Yes, yes.
One is that whether I need to take the defense in the written statement at all. So there is one position of law which says that I don't need to put it up in my written statement at all. I cannot even be forced to put it up. In fact, I can even take it up orally with regard to a defense on jurisdiction.
That is no more the applicable law. শেয়ার করতে যাচ্ছে কি দেখতে পাবে তুমি এখানে? এখানেও তো স্ক্রিন আমি দেখতে পাবো না।
I'm sorry, Lordship. I beg your pardon, Lordship.
See, you can share it, but the difficulty is that the video screen is so far from me that I won't be able to read.
I'll just inquire in how much time is the. I apologize for that.
You give the citation. Let us start. Let him come, because here the advocates are always late. The first 5-7 matters every day has to be passed over.
I'm sorry. I apologize for that. I'm actually arguing from Ahmedabad, Gujarat. But yes, sir.
Yes. What is the judgment you are citing?
Sir, first is Karnataka High Court. It is, if I can give Karnataka LJ or Manupatra, what would be convenient, Lordship? There is ILR, I have Karnataka LJ, I have ICC, and I have HLR.
It is not in SCC online.
Sir, it is. No, sir, we do not have SCC. We have. If Manu citation would work, sir, Manupatra citation.
Manu citation I don't have. It's very convenient if you can give from SCC online.
Sir, the prints will be handed over for sure, sir. If I can, I'll just give the writ petition number then. If the order.
Manu. What is the Manu here?
So it's Manu stroke KA.
AA.
K for Karnataka, KA stroke 1809 stroke 2024.
Stroke 1809.
Yes, sir.
Stroke
2024.
This is a DB or SB?
Sir, it's a single judge, sir. I just read the relevant paragraph, sir.
Which paragraph?
Sir, it's paragraph 10 in the Manupatra citation.
Yes.
Sir, I just read that Order 7, Rule 10 of the CPC permits filing of an application for return of plaint. Subsection 1 of Section 10 permits the concerned court to return the plaint to be presented before the court in which the suit should have been instituted. The procedure to be followed on returning the plaint is dealt with under subsection 2 of Section 10. Order 7, Rule 10 of CPC touches upon the jurisdiction of a court to have entertained a suit. The question of jurisdiction cuts at the root of the matter, and if the court has no jurisdiction, territorial or otherwise, to entertain a plaint, it cannot. Who brings up the issue before the concerned court is immaterial, as Order 7, Rule 10 of CPC nowhere indicates that it is only to be filed by the plaintiff and not the defendant. What is brought to the notice of the court qua jurisdiction is what is important and not who brings it. In a given case, a defendant has a right to file application or even raise an oral objection for raising ground based on Order 7, Rule 10 or Order 7, Rule 11 of the CPC. The court cannot direct the defendant to file a written statement for raising objections.
Yes, this is the distinction. Where you have filed the written statement, this is at the pre-stage of the. Suppose
Yes, sir.
you are served with the summons.
Yes,
Then
sir.
you can come and say that
Yes.
look here, the court does not have the jurisdiction. The
Yes.
court cannot force you to file the written statement,
Yes,
but
sir.
the court will take note of the jurisdiction issue because
Yes.
it goes to the root. But where you have already filed your written statement, then the question is the delay and the point taken in the written statement. See, today, if you have not taken this point, then even at the final stage,
Yes,
when
sir.
you adduce evidence, the court cannot look into it.
Sir, actually, even at appellate court jurisdiction, the plaint can be returned.
Yes, can be returned. I can give you judgments, no
Yes, sir.
difficulty. But there you have to take the jurisdiction issue at the threshold.
Yes, sir. Sir,
I can give you a judgment. Oriental Bank, Calcutta Division Bench judgment, where because if you see section 21 of the CPC,
yes,
at the appellate stage you cannot take up the jurisdiction. It has to be taken in the trial court, and in the trial court, jurisdiction issue has to be taken at the threshold.
Sir, just on the written statement, sir. So I understand that one is, of course, when I make a denial, it may not perhaps be a mere denial, and that is as far as allegations is concerned. So I was asking myself this question that, sir, as far as jurisdiction is concerned, in my written.
Sir, the little I understand. When we draft a written statement, the first few paragraphs, the suit is not maintainable as framed. If there is a lack of territorial or pecuniary jurisdiction, second point, this court does not have the territorial or pecuniary jurisdiction. Third, if the suit is bad for non-joinder or misjoinder of parties, the suit is so. These are the first few paragraphs. There is nothing. Even I could have understood while dealing with the paragraph, you have asserted that this court has no jurisdiction because the invoice, which is the last year, which you are now submitting. Now, see, civil matter is not like REIT where we have the discretion. It has to be specific, either yes or no. Otherwise, one has to go.
Yes, sir. So, sir, so just on this positive assertion,
there is no positive assertion. I've seen it.
So that's what I'm coming to, sir. Sir, so if I were to have denied this court's jurisdiction, and there is a denial in the written statement.
No,
But
the denial is no cause of action.
No, sir. It is the denial is for the entire paragraph that is there.
I've seen that. I've seen that.
Yes, sir. Denial is there for all the lines of that.
And unfortunately, the person who has drafted, I will not blame him for reasons best known to him. See, when we deny something,
Huh, sir.
it can be, see, if you go by the classical pleading and drafting books like Muga and others, where you don't have a knowledge about a thing, you have to deal it as not a fact. Where you are sure this is not the case, then you have to deny it as alleged or at all with the sentence ending. And if you are not sure, then you have to I dispute. So these are the classical ways of pleading. Now people have given a go by doing writ petitions. Everybody is, and unfortunately, writ petition is a summary proceedings where in the affidavit you have to state everything. Now we don't go by the technicalities, but in civil matters you can't help.
Yes, sir.
Because the provisions of court is very clear. You have to deny it, there cannot be any evasive denial. You have to assert it, you have to assert it.
Sir, so
That's the reason the defendant is permitted to take even contradictory stand in the written statement.
yes, sir.
Plaintiff can plead alternative case, but at the trial, the plaintiff has to choose any one of it. But the defendant, even at the trial, can go for the contradictory stand. So,
Sir, I am grateful, Lordship, and I understand that these denials and because of the writ petitions, but just to add to that, sir, in Gujarat, otherwise English is not first language. So even the drafting,
maybe.
So
In our state, English is also not the first language.
yes, sir. So if the drafting
Only in the chartered high court.
Yes, sir.
The
Sir,
English is the official language.
sir, we've seen that in Bombay.
So in original side, even if you rely upon any vernacular document, you have to give an official translation.
Please.
But in case of appellate side matters, even vernacular languages are permitted to be document in vernacular language is permitted to be annexed.
Yes, sir. So just to yes, we've seen that in Bombay the language is better here. So in Gujarat, sir, what I'm saying is that
Don't say so. Gujarat bar. I had the occasion to visit Gujarat High Court when I was at the bar, not once, quite some time. The Gujarat bar is very well equipped.
Sir, High Court is different from trial court. The trial court lawyers have different. But anyways, we don't want to. I'm not saying.
No, that you will find in the Upa case or in the earlier judgments, you will see there was a nomenclature called mufassil pleading. But I tell you, in my experience in civil court, in the district courts, 4-paragraph petition, you won't be able to come out of it. Everything is stated over there in 4 paragraphs. See, the CPC in the appendix, you will see a plaint has to be drafted in 5-6 paragraphs.
Yes.
We hardly can do. Because now the issue has become so complicated, it cannot be done.
Yes.
Secondly, with the advent of the writ petition concept, we try to even put in evidence in the pleadings, which is not necessary.
Yes.
So that is not. See, next judgment.
Yes, sir. Sir, so my request would be that the Lordship may consider the denial, but just that point that I understand that I have to give a positive assertion, but I was just thinking that why would I guide the other side as to which would be the correct forum? No. I would deny that this is the wrong. I would say that this is the incorrect forum. That is my denial. But then for me to assert and then guide him that no, you please go.
Denial is also not in the form that this court does not have jurisdiction, because there was no pleading to that effect.
Sir, there is the paragraph 23 in the plaint is.
I have read it thrice. You can, for your satisfaction, you can again read.
Yes,
but
sir.
You will not find it.
Sir, with the permission, I'll just read that because so first we may read the paragraph in the plaint. so that the dots are connected, Lordship.
Yes, paragraph. Which paragraph? I will read it. No difficulty. You show
Yes,
me
sir.
that there is an assertion of jurisdiction which has been denied by you. Paragraph, which paragraph of the plain?
The paragraph 22, sir.
Dealt with in paragraph 23 of the written statement.
Yes, sir. It is dealt with in paragraph 18 of the written statement, sir.
Very well. Paragraph 18 of the.
Yes, sir. But we may first read para 22 at page 22 of the plain. Sir.
Yes.
The learned court has the jurisdiction to entertain and try the suit in as much as the purchase order in question were. So then it's were prepared and signed
Yeah.
by both the parties, that is by the defendant company through its authorized representative, Mr. Manish Patel, and also by the plaintiff company at Siliguri within jurisdiction of Siliguri. The payment by way of checks, online payments were made by the plaintiff company to the defendant company of Siliguri, and the defendant company above named provided the said grinding plant, equipment of the work site of the plaintiff company at Siliguri and commissioned the same through its service engineer, and the entire cause of action arose at Siliguri within the jurisdiction of this court. As opposed to that, at page 32, para 18.
Read.
That in answer to the paragraph 20 to 23, the defendant states that all the allegations made therein against the defendant in the whole plaint, and these paragraphs are false and concocted and vehemently denied by the defendant. The plaintiff has not come with clean hands and has virtually suppressed all the material facts in question, and the plaintiff is not entitled to any relief whatsoever claimed herein. Thus, the plaintiff has no authority to make the claims made by him in this suit. No cause of action ever arose for the present suit at any time, and the plaintiff has no locus standi to file the suit. As such, the present suit is absolutely bad and amounts to an abuse of process of law. The plaintiff has no case at all to speak of. The suit has been filed with an illegal and malified intent to flout the laws of the country and illegally extort money from the defendant and avoid its liability to pay the due amount to the defendant.
Where initial paragraph, this court has the jurisdiction in as much as this thing. Where have you denied that?
Sir, it's a general denial.
See,
But sir,
will not do.
Sir,
A specific pleading jurisdiction. You have not uttered any word regarding the jurisdiction. Sorry. And take down.
Sir, I'll just,
You can, but unnecessary, because your pleading does not support your case. Which are what your junior has not yet come.
Sir, I'll just, with the other judgments, I'll just, the proposition of law, whether the written statement is to be looked into at all. So the Honorable Supreme Court says that the written statement is not to be looked into. It is only the plaint that is to be looked into for the purpose of return of the, so whether my written statement is to be considered at all.
Sir, you are absolutely right, because in case of Order 7, Rule 11,
Yes, sir.
the statement contained in the plaint,
Yes, sir.
are required to be taken as true and correct.
Absolutely,
Now,
sir.
if you look into the Liverpool judgment, previously the view was you can look into the plaint and only into the plaint.
Yes, sir.
Subsequently, in Liverpool and thereafter, that is probably 2004 or 5.
Yes.
From there onwards, you will find that the court has said that while deciding an Order 7, Rule 11, the documents annexed to the plaint can also be looked into.
Yes, sir.
Now, this has been reverberated in 2008 and even subsequent thereto.
Yes, sir.
So, it is a simpliciter case that this issue,
Yes.
because I cannot look into the jurisdiction of, I cannot look into the defense of the defendant while I adjudicate an Order 7, Rule 11 application.
Yes, sir.
Because, but Order 7, Rule 10,
Yes, sir.
maybe there are, so far as I understand, there are at least 2 or 3 judgments which say the same principle has to be followed. But in such a case,
Yes, sir.
Where you are filing the written statement, you are filing the Order 7, Rule 10 after 12 years, there nothing remains.
But sir, as far as the suit
Sorry,
is concerned,
sorry. Sorry.
it is not moved to the stage of judgment or final hearing, sir. It is
Maybe,
still at the
maybe. But the
inception.
trial has commenced.
But Lordship, it is the trial, is the examination by the plaintiff,
No,
sir.
no. Oh, hold on. Any further judgment?
Yes, sir. So,
Don't flog a dead horse. Don't show me judgments. We in the same line which you have already shown. Because I am not agreeable with the not with the ratio, but the applicability of the judgment.
sir, so
There is no dispute. Which you say absolutely correct. Or written statement cannot be looked into, all these things. But you are coming at what stage?
but sir, as for even the stage, in fact, the language of 710 itself, it says that it can be returned at any stage. So
Very-
sir, I ask myself why it is that what prohibits me from raising it at this stage, even if I did.
No, sorry, not at this stage.
Sir, it's a Lordship may have 710 and judgments of the Supreme Court direct on this point, sir, that the plaint can be returned at any stage. Lordship may
Sir, the issues were framed. Did you get the issue framed that this court does not have the
Sir, there
jurisdiction?
was no representation from my side.
So what can be done? What can be done?
But sir, that is not the criteria, sir. If
Yeah,
you-
it's a absolute criteria. Absolute criteria.
But Lordship may have
Because see, in cases where you need to look into some evidence, like the point of limitation. The point of limitation is a mixed question of law and fact. In certain cases, only on the legal point and ex facie when it's barred by limitation, the court can at the threshold dismiss it. Otherwise, the court can frame a preliminary issue and look into it. Now, if you had raised this objection, it's too late. Your entry to the matter and your legal advice is at a very belated stage. Sorry.
Sir, there is a
Anything
direct
further?
judgment. There is a direct judgment of the Supreme Court. Sorry, this is sorry, Calcutta High Court itself, Lordship.
Yes, tell
Of 96,
me.
where
Yes.
it says that a preliminary issue need not be framed, sir.
That has been diluted subsequently by the Supreme Court. And there is already a reference pending now. There was difference in opinion in respect of limitation 2023 or 22 or 20. It has been referred to the larger way.
Sir, I'll just read that it is the judgment in the case of Nilima Bose versus Santosh Kumar Ghosh. It was before Lordship Ashok Chakravarti, sir. And I'll just read the relevant paragraph. It is therefore clear that if at any time
much water has flown through Ganges and through Narmada in between. The law has now changed its shape. Very well. Anything? Take down.
Sir, but sir, if that were the case, then at any stage will have no meaning, sir. That then it is qualified by whether you've taken please, whether you've put it in whether a preliminary issue is framed. All of that language is not present in 710, sir. And 710 says that once the court finds and Lordship believes that if in the invoices, which is the last understanding between the parties, then that is the jurisdiction of the court that is agreed upon between the parties, sir. Sir, may please consider.
I have considered it. Take down.
Sir, just for a moment, we're just verifying in the issues whether there is anything on jurisdiction, because we've arranged for the copy of the lower court proceeding. Just if my lords, just 1 minute, my colleague is immediately going through. I'll just 1 moment. We'll check if there is something on the issues, sir. Or can my lords consider directing the court to consider an issue on jurisdiction, sir? But at least that can be done,
There
sir.
is no pleading.
But
If
sir,
there is an issue can be framed only where there is an assertion and denial.
Sir, like limitation, even jurisdiction, if it's upon the
No,
court to say
no,
limitation, I
no,
need
no.
not plead, sir.
Sorry.
Sir, limitation, I need not plead. It is for the
No,
court to say.
no. Sorry, limitation is something different and jurisdiction is something different.
But sir, it is
Limitation cannot be waived, but jurisdiction can be waived.
Sir,
Please don't make unnecessary to continue with the argument. Don't make unnecessary arguments.
sir, my only request is, Lordship, may please consider.
Sorry.
Lordship is convinced of the view that is the last understanding between the parties. Let it be heard by the trial court then.
You have not taken any point.
But sir, I am saying there is a denial. Lordship may permit that at least that limited aspect may be there.
Sorry.
That's all I am asking for, sir.
Sorry, you make an application if the trial court issues can be recasted. You have to make an
Then
application.
Lordship may consider giving me liberty to make that application.
No liberty.
Sir, may please consider. Lordship,
The moment I give you liberty, it will be bestowing you with a blessing. Sorry.
Sir.
No. Mr. Seth, please. Now let me dictate. This revisional application arises out of an order dated
January 2025.
Which page is the order?
Milords, I believe it must be a certified copy, but otherwise, Milords, is 148 also last page of the application. 148.
Yes.
Sir, 148 is the.
Let us see. Order dated 31st January 2025, by which না কি বললাম তোমার by which the application filed by the
Sir, only I'm sorry, my colleague has just brought to my attention one more paragraph. If my lords, I'm sorry, I didn't mean to interject, but since he's brought, I'll just
enough. I had enough. Sorry.
Only para 7 of the written statement, Lordship may see at page 2025. Lordship may only consider it says that there is a pending proceeding before Ahmedabad. That is the point, sir. And
sorry. Sorry.
Why is that filed by the
কি বললাম দেখো
out of an order dated 31st January 2025 by which the application filed by the
being the defendant in the suit under the provisions of Order 7, Rule 10 of the Code of Civil Procedure 1908, in short CPC, on 4th January 2025 was dismissed. The suit was filed হ্যাঁ ওই ফাইল নিয়ে ওইটাই তো সুট নম্বরটা দেখছি When was the suit filed?
Milords, 15th June 2013. Milords, I am seeing from the order sheets that I have. 15th June 2013.
in কি বললাম in filed on নিয়ে in ms ব্র্যাকেটে কম
File and order থাকবে আমি pass in করে দিই।
হ্যাঁ না পাস্ট না কি বললাম
That thing arises out of an order dated 31st January 2025.
হ্যাঁ
By
Sir, I don't know if 2013 because the verification is of 13th February 2014.
So I have the order sheet, Mr. Seth.
Yes,
think
but Lordship, my page 33, the verification of the plaint is of 13th February 2014.
whatever maybe whatever 14 or 13 it makes hardly any difference because it is past 13 years.
I cannot say anything further on that, sir.
হ্যাঁ কি বললাম
this application arises out of an order dated 31st January 2025. By which application filed by the petitioner being the defendant in the suit.
suit
Being
being ms ব্র্যাকেটে কম 05 of 2022 হ্যাঁ
under the provisions of Order 7 Rule 10 of the Petrol on 4th 1 2025
filed on was dismissed. The suit was initially instituted on
15 June 2013, Manoj.
15 June 2013. Houston. And has now been renumbered in view of the provisions of the Commercial Courts Act 2015. Houston. The suit, in this suit, the defendant has filed its written statement. When was the written statement filed?
13th February 2014, Manoj. Impugned order records this.
13th February
2014.
2014. Full stop. On a perusal of the application under Order 7 Rule 10 of CPC, it appears that the main ground on which the defendant has objected to the jurisdiction of the learned jurisdiction of the commercial court at Siliguri is that the tax invoice raised by the defendant on by the petitioner bracketed defendant on the opposite party bracketed হচ্ছে plaintiff contains a jurisdiction clause by which, according to the defendant, the parties had agreed to confer jurisdiction in the courts at Ahmedabad. It is the case of the petitioner bracketed defendant that on having accepted the said invoice and acted upon therein, on having accepted the said invoice and the plaintiff and the opposite party, bracket plaintiff, having acted thereupon by making payment, has accepted the jurisdiction, clause. Postal. On having accepted such jurisdiction clause, it has to be, according to the petitioner, construed that the jurisdiction of all other courts have been excluded by the parties. Postal. In that view of the matter, the jurisdiction, in that view of the matter, the jurisdiction of the commercial court at Siliguri stands excluded. Postal. Records also reveal that the petitioner, prior to institution of the suit by the opposite party in the Siliguri court, had instituted a suit on the self-same cause before the district court at Rajkot or Ahmedabad district court. Where did you?
Ahmedabad, Milad. Ahmedabad.
Sir, Ahmedabad, sir.
At Ahmedabad. It also appears from the record that the said suit stood dismissed and an application for restoration of the said suit is pending. It is therefore clear that at the present there is no suit pending before the district court at Ahmedabad. Next, the petitioner says that an application under Order 7, Rule 10 of CPC can be filed at any stage, and cites, where is your junior? Is still coming?
Sir, I'm just,
Sorry,
sir,
Mr. Seth, this
sir,
is
we
not-
are following up with them, but I'm sorry.
কি বললো?
Petitioner says that an application under order 7 rule 10 can be filed at any stage.
In support thereof, the petitioner has relied upon a judgment reported in Manu /KA oblique 1809 oblique
Manu oblique
1809 oblique 2024. Manu oblique KA, capital K, capital A. তারপর হ্যাঁ স্ল্যাশ ওই তো Manu /KA /1089. This is a judgment passed by a single bench of the Karnataka High Court. The opposite party, bracketed plaintiff, has objected to this application on the ground that the learned commercial court at Siliguri, after due appreciation of law and fact, has passed an order assigning reasons for rejecting the petitioner's apostrophe S application. Moreover, the opposite party says that this application is a belated one filed after 12 years from the date of institution of the suit. The suit has progressed to the trial stage and witness action is going on.
Please, my lords.
At this stage, with an ulterior motive and malafide intent, the application was made by the petitioner for return of the plaintiff. Furthermore, the opposite party says, the opposite party says that in the written statement, nothing has been pleaded about the exclusion of jurisdiction. No specific assertion has also been made in respect of lack of territorial jurisdiction at in respect of the courts at Siliguri. It is also the case of the opposite party that the petitioner, bracketed defendant, has not denied the jurisdiction of this court while dealing with the averments made in the plaint. In this context, the opposite party refers to paragraph 23 of the plaint, which has been dealt with by the petitioner, bracketed defendant, in paragraph 18 of its written statement. The opposite party therefore says that this application should be rejected. In response, the learned advocate for the petitioner has said that there is no necessity for taking the point of jurisdiction in the written statement. If the point of jurisdiction can be orally raised and the court is not required and the court is precluded from looking into the defense while hearing and deciding an application under Order 7, Rule 10 of CPC. Full stop. Next. After hearing the parties and considering the materials on record, I find that the issue of jurisdiction, which is required to be raised at the threshold as per the settled provision of law, has been raised after 13 years, and that too without any pleading to that effect in the written statement, on the basis whereof the trial has commenced and proceeded to a substantial extent. Full stop. Ordinarily, the jurisdiction of the suit, both pecuniary and territorial, is governed by the provisions of Section 9 and Section 15 to 20 of the Code of CPC. Full stop. The ordinary forum for filing a suit is in the ordinary forum of filing a suit, which does not relates to adjudication of right in respect of an immovable property, is where the defendant bracket S reside or carries on business. Full stop. In the instant case, the defendant, in the instant case, the plaintiff is admitted to carrying on business at Siliguri. So, under ordinary course, the defendant, ordinary course, the petitioner bracket A defendant, if it had to file a suit, had to file it in Siliguri. The exception carved out in the aforesaid provisions of CPC is that where a part cause of action has arisen within the jurisdiction of a particular court, the plaintiff may institute the suit in one of such courts, pleading the reasons for filing the same in that code. The transaction between the between the petitioner and the opposite party relates to sale of goods. The cause of action of which arises if not otherwise agreed between the parties at the place where the plaintiff carries on, place where the petitioner carries on business, or at the place where the defendant resides or carries on business. Part cause of action in a sale transaction arises out of arises at a place where from the invoices are raised and invoices are raised, comma, the goods are supplied, comma, invoices are received, and goods being delivered. The making of payment and receipt thereof also comprises a part cause of action. Going by this rule, the courts in Ahmedabad, as also the courts in Siliguri, have jurisdiction to receive, entertain, try, and adjudicate a suit. Receive, entertain, and determine a suit. The কি বললাম the
What would you do? The courts in Ahmedabad and also the court of Jalpaiguri have jurisdiction to receive, entertain, and determine the suit.
determine a suit. It cannot therefore be said that the courts in Siliguri completely lacks the territorial jurisdiction to receive, try, and determine a suit between the petitioner and the opposite party. Next. It is correct that exclusion of jurisdiction contained in the invoice upon having been accepted and acted upon confers the jurisdiction confers the jurisdiction to the forum selected therein. On the basis of the tax invoice, on the basis of the jurisdiction clause in the tax invoice, on having been accepted and acted upon, the petitioner is entitled to contend that the jurisdiction of the courts in Siliguri got excluded. Got excluded. The petitioner was, however, required to take this jurisdiction issue at the threshold, even without filing the written statement. When the court could have decided on the jurisdiction, on the exclusion of jurisdiction as now contended by the petitioner. It is no more res integra that even if an application for Order 7, Rule 10 under CPC is permitted to be made at any stage, but the same has to be at the threshold. The petitioner in the instant case has challenged the jurisdiction after 13 years, and that too after filing the written statement. On a conjoint reading of paragraph 23 of the plaintiff and 18 of the written statement, I find that there is no assertion that the courts in Siliguri does not have the jurisdiction to receive, try, and determine this. The exclusion of jurisdiction of Siliguri court has also not been specifically pleaded in the written statement by citing the tax invoices as has now been sought to be done. The petitioner in its written statement has not denied the jurisdiction of Siliguri court or asserted that Siliguri court does not have the jurisdiction in any part or portion of the written statement. Of the written statement. It is also well settled that the jurisdiction clause between the parties can be waived either expressly or by way of conduct. The defendant has participated. Now, the petitioner, as the defendant, has participated in the suit for 13 long years, which has proceeded to the stage of trial. The petitioner, therefore, by its conduct and having not raised the jurisdiction issue at the threshold or even in its written statement, has to be considered to have waived the objection to the jurisdiction of the Shiliguri court. That apart, and in any event, the balance of convenience is one of the factors regarding the jurisdiction. The petitioner, while entering into the transaction, was well aware that entering into the transaction with the opposite party was well aware that the petitioner was required to was well aware that the petitioner may have to either prosecute or defend in connection with any dispute between the parties in the court at Shiliguri. The petitioner has participated for 13 long years before the Shiliguri court, and as such, the petitioner cannot also say that the court at Shiliguri is forum inconvenient to the petitioner. That apart, and in any event, the petitioner has not objected to the jurisdiction of the Shiliguri court at the threshold, but submitted to it by participating, by filing written statement and participating at the trial. Considering all these aspects, I find that the learned judge was correct in rejecting the petitioner's application under Order 7-10 of series. In the light of the discussion as made herein above, and on a close scrutiny of the order input, I also do not find any infirmity in the said order. The revisioner application therefore fails, and is accordingly dismissed.
Very
Grateful,
well.
Milord.
I'm grateful. But we only consider that
Milord.
liberty, that at least that issue may be considered, since
I will not transgress into the jurisdiction of the district of the commercial court.
it's a
Milords, may I say this, Milords? I don't know if I'll get an opportunity to appear, but it's been a pleasure. Your Lordship's given a masterclass on civil and arbitration law in the last few days, Milords, that I've been observing. Milords, deeply obliged.
we are extremely grateful, Lordship. With the permission, may I log off, Lordship?
Yes, yes.
Obliged.
Milords, remind me of Justice Nariman, who remembers judgments like your Lordship do. Milords, with years, with para numbers and all that. So that's something for us to learn as juniors, Milords. Deeply obliged, Milords.
Item number 2 under forward.
Milord, I picked to appear on behalf of the opposite party, Milord.
Yes. Oh, it is to judgment reserved. Yes, come. This revisional application arises out of an order passed by the learned arbitrator on 4th March 2025, by which the petitioner's application for amending the statement of claim was rejected. Before going into the merits of the matter, it is necessary to deal with the issue of maintainability of an application under Article 227 of the Constitution of India. For assailing an order of rejection of the amendment application as raised by the opposite party has to be gone into. It is the submission of the opposite party that going by the scheme of the Arbitration Act, which has been promulgated with the main object for speedy disposal of a dispute between the parties before a chosen forum without much intervention of the court, will get frustrated if applications under Article 227 are allowed to be entertained in respect of each and every order passed by the learned arbitrator, arbitral tribunal. The opposite party refers to the provisions of Section 37 to submit that the orders passed by the learned arbitrator which are assailable have been specified therein. A rejection of an order, rejection of an an order of rejection of an amendment application does not fall within such category, and as such cannot be assailed before the court by invoking the jurisdiction of Article 227 of the Constitution. কটা বাজে গো? একটা পৌনে 12টায় বোধহয় ইয়ে বলেছিলাম।
And an order of rejection of an amendment application fall to be such category, and as such cannot be accepted before the court by invoking the jurisdiction of arbitration.
The opposite party in this context relies upon the judgment reported in reported in 2020 15 SCC 706 by relying upon the said judgment. It is submitted that an application under Article 227 in the facts of the instant case is not maintainable. On behalf of the responding to this objection, on behalf of the petitioner, it is urged that the power of superintendence under Article 227 against the orders passed by a domestic tribunal like an arbitral tribunal remains.
But we take a seat now.
Yes, remains unumbrated, even in view of the provisions of the arbitration clause, and in particular the wording in section 5 of the Arbitration and Conciliation Act 1996. The petitioner has cited a judgment a division bench judgment of the Karnataka High Court. Do you have this? Do you have the SCC reference of this judgment? Karnataka
Which
division.
one? Will?
That
Kelvin.
no, Nagaraj.
No, that's this. This is an unreported law. This is only reported in this law finder. Only found in this journal. I could not find any other
division bench
citation.
judgment delivered on September 2nd, 2022. In writ petition number 14573 of 2022, bracketed Sri N full stop S Nagaraj Reddy versus Biren BIREN Corporation, bracketed formerly, comma, S capital JR Choto Enterprises. Full stop. এটা দেখে নিয়ে এখানে to content that an application under Article 227 of the Constitution of India is maintainable against an order of rejection of an application for amendment of the statement of claim. The petitioner has also relied upon a. Do you have this Kelvin?
Yes.
Do you have the SCC citation? Nothing in SCC. It's there.
It's online search.
Has
Expedition has also delivered a
reported in 2024 SCC Online, Dell 7137. Bracketed Kelvin Air Conditioning and Ventilation System Private Limited versus Triumph Reality Private Limited. Cost. On a reading of the judgment in Deep Industries Supra cited by the opposite party, and in particular paragraph 17 thereof, it has been clearly held that applications under Article 226 and 227 are maintainable, but Article 227 করো, শুধু 220 against কি বললাম
you know, these are industry certificate of different and particular same thing there are. It has been clearly made that applications under Article 57 are maintainable or
are maintainable against judgments allowing or dismissing first appeals under section 37 of the 1997 Act. But the High Court should be extremely circumspect in interfering with the same, taking into account the statutory policy as adumbrated by the Honorable Supreme Court in the said judgment, so that interference is restricted to orders that are passed which are patently lacking in inherent jurisdiction. Thus, it cannot be said that in Deep Industries Supra, the Honorable Supreme Court has completely eliminated the application, eliminated the applications against orders, application under Article 227 against the orders passed by the arbitral tribe, but has clarified the restrictive provision thereof. In deep industries, the Honorable Supreme Court has taken note of the previous judgments as also the provisions of the of the 1996 Act to hold that an order rejecting an application under section to hold that revisional application does not lie against an order rejecting the application under section 16 of the said act. The judgment of the Division Bench of Karnataka High Court, though considered the order, though considered a revisional application against an order passed by the learned arbitrator inter alia on the principles of Order 16 or Order 6, Rule 17 of the Code of Civil Procedure 1908, in short CPC, but has not discussed the maintainability aspect of the application, probably because no objection had been raised, for which the court had no occasion to deal with. The Delhi judgment in Kelvin air conditioning holds that an application under Article 27 against an order কি বললো?
holds an application under Procedural 7 against an order
to allow or reject the extension of time to file the statement of claim or statement of defense is maintainable on the basis of the ratio laid down. In 2023, SCC Online Dell 4052 bracketed IDFC First Bank Limited versus Hitachi all caps MGRM net in cap NET Limited. In paragraph 24 of IDFC Supra, the following has been held, which is quoted in Kelvin Air Conditioning Supra. The said paragraph is as follows. Set out করে দেবো, ঠিক আছে? হ্যাঁ, এটা না আছে। Better set out. On a conjoint meeting of the judgments cited by the petitioner and the opposite party as aforesaid, I have no dispute as to the ratio laid down therein. It is true that an application under Article 227 challenging an order of the arbitrator has to make out an exceptional case, particularly the order has to be perverse, and patently lacking in inherent jurisdiction. The High Court has, as discussed herein above, cautioned by the Supreme Court about exercise of jurisdiction under Article 227 of the Constitution of India. The judgment of the Delhi High Court has also taken note of this caution, while Delhi High Court in IFDC Supra has also taken note of this and have laid down the conditions for entertaining an application under Article 227 in paragraph 24 hereof. I, however, intend to look into an order passed by the learned arbitrator, either allowing or rejecting the same from a further angle apart from those discussed in the judgments referred to herein above. An application for amendment of the an order rejecting the application for amendment of the statement of claim or statement of defense, or allowing such application is not appealable under the provisions of Section 37 of the 1996 Act. However, either by allowing or by rejecting such an application, the rights of the parties are gone into. First. Moreover, a party cannot be made to wait till the completion of the arbitration proceedings in a case where he is aggrieved by the order allowing the amendment or rejecting the same. If the amendment is allowed, then the trial would commence on the basis of the amended amended pleadings. The trial, therefore, would shift from the trial, therefore, shift at the end of the trial, the prejudice suffered the prejudice suffered by a party aggrieved by the application being either allowed or rejected will have to challenge the same while challenging the award. If a party succeeds in its challenge regarding the order allowing or rejecting an amendment at that stage, then the entire exercise has to be redone. Redone. This, in effect, will frustrate the object of the arbitration of the 1996 Act for speedy and effective resolution of a dispute. Furthermore, it is well settled. এই ওই দুটো জাজমেন্ট নিয়ে এসো তো ওই কালকে দিলাম না যেটা 2002-6 SCC আর হচ্ছে 1993 সাপ্লিমেন্ট টেবিলে রাখা আছে। হ্যাঁ, না না না, ওই বইটার জন্য আমারই ভুল হয়েছে, আমি বলছি এখানে আছে। আমার টেবিলে রাখা ছিল তো। আর একটা কোথায় গেল? 93-টা হ্যাঁ। হুম, 6 SCC। 6 SCC 60।
This is a constructive clause. This is that resolution of this. After
Furthermore, as held in 19 as held by the Honorable Supreme Court in the judgment reported in 1993, Supplement 2, SCC 433, in paragraph 86 thereof, that quote unquote where statute is silent and judicial intervention is required, courts strive to redress grievances according to what is perceived to be principles of justice, equity, and good conscience. The Supreme Court also held in the said judgment, quote unquote, in paragraph 84 thereof, quote unquote, the cause of justice can never be allowed to be thwarted by any procedural technicalities. It is also held by the Honorable, next quote, it is also held by the Honorable Supreme Court in the judgment reported in 2002 6 SCC 16. In paragraph 25 thereof, dash দিয়ে, quote unquote, that every wrong must have a remedy and every right to relief must have a forum for enforcement. In the light of the ratio laid down in the aforesaid two judgments, it can be seen that no appeal is provided under section 37 of the 1996 Act against an order rejecting or allowing the amendment to the statement of claim or statement of defense. Though such provision is such provision, though amendment to statement of claim and statement of defense is specifically provided under section 23 of the said act. A party therefore aggrieved by such order has to have a forum to challenge the same. Because waiting for the arbitration to conclude with the passing of the award and challenging such order as a part of the challenge to the arbitral award, as discussed here in above, will frustrate the entire object of the 1996 Act. In the aforesaid facts and circumstances, I hold that an application under Article 227 is maintainable to challenge either challenge an order, either rejecting an application for amendment of the statement of claim or defense, or allowing the same. Next part, I will dictate it via, but I have checked. I am not agreeable to allow the amendment. I make it very clear. In the statement of claim, there is no single averment about the application for obtaining loan. Now, readiness and willingness, you have pleaded. You said ready and willing, but it has to be.
No, but the 85 lakhs.
Just a minute.
But
I have also checked the language of the amendment paragraph which you intended to insert by way of amendment.
Yes, Lord.
It starts with in the meantime.
Yes.
So, in the meantime, in the context of when?
In the which was just
No, sorry. In the you have to say specifically that on which date you had made the application.
Lord, the loan was sanctioned.
Maybe loan was sanctioned.
Lord, there is a reflection about it
Lord,
in the order.
They have
In
an
the order,
opportunity to object to that in their additional statement
Sorry.
of defense.
I have checked it.
Lord, if I may just place one judgment.
No judgment. I have seen all
Lord,
the judgments.
if it is a subsequent, if the cause of action arises subsequent to the filing of the suit, that amendment may be brought on record.
I am aware of it.
Milord takes the judgment, Milord.
If that is the
I
principle,
am aware of it. No difficulty.
Milord, in the
If that
second,
is
I will deal with it.
second point, Milord, the delay in filing the amendment has not been adequately explained in the order it is written.
it's a simple amendment, but they have a right to file their additional statement of defense.
Sir,
I may not
sir,
succeed at that
according to
particular
you,
point in trial.
according to you, it may be simple, but to me it is very complex. In a suit for specific performance,
Yes, sir.
you have to be very careful. I will check the Supreme Court judgment that if a specific performance suit is not in accordance with the provisions of the appendix in CPC, it is liable to be dismissed. You want that judgment? I can give it to you here and now.
Milord, if Milord may provide that citation.
Why?
It would be of great help.
Let me see.
I am very much grateful to your Lordship.
It's a matter of this remember came that could be upgraded to tomorrow. There are only 2 days remaining, and they are
No, what is the reason for upgradation?
the reason for upgradation.
See, the difficulty is that whenever the matter is called on, it is passed over.
Last day it was heard minor, a second chance was given. They have refused to take the service for the second time minor, and in the
Which, this is the matter where Mr. Bikromjit Ghosh was appearing.
this item number 10, linked to the CU, that same minor claim was at 711 petition, the rejection against which we preferred an revisional application.
Yes.
We have minor has asked us to direct us for a second service. They have refused it, my lord. And my lord, we are not
See, not that urgent to upgrade it. If I am able to reach, I will reach.
my lord, we are not covered with any stay order, my lord.
May not be.
It's
Why?
This proceeding, my lord.
See, all Order 7, Rule 11 applications are not that simple. It is aimed at something different. ভেতরে কাগজ ছিল না, কোথায় গেল? কাগজটা ফেলে দিল? আচ্ছা। See, which judgment are we referring to? 2014 8 SCC 294.
Lord, on the point of subsequent
Subsequent
amendments?
2000, see,
No,
2000.
Lord, I'm referring to 2006, Volume 4, SCC 385. Rajesh Kumar Agarwal versus KK Moon.
Okay, I have seen that. You have cited it.
Yes.
Also. I have seen that. The latest judgment which I have, there may be something more. 2014 8 SCC 294, paragraphs 48 to 53.
But this judgment is perhaps there in the commentary to Sibisky. If I may.
I'm often not getting it, but I will look into it. It's there. I will give you the judgment. It's there. If it has to be according to the appendix as the content in CPC, otherwise it is to be rejected.
Lordship,
Let us see. I said if I can. You saw.
Lordship,
By series there.
Yes.
Lordship, yes, Lordship, item number 12, Lordship, it is a custody matter, Lordship. So my interim custody has not been decided for last 4 months, Lordship. So I have prayed for a direction for speedy disposal, Lordship. Can it be? It will
I
be,
will try to. I will try to take it up tomorrow because
Lordship. Can I get a preference on that, Lordship? Lordship.
if I give you a preference, everybody will now come and mention for a preference. The entire list will get.
Lordship, a little bit of
occupied.
upgradation, Lordship.
Let us see what can be done.
Lordship, Lordship.
ওই 12টা আর 10টা আর 12টা 10 নম্বরটা মেনশন করলে যাওয়া হয়ে গেল
Lord, in this matter, there is also a CAN application filed by the Millers.
for what can
Because
application
CAN was for extension of the stay grant.
that I will
Grateful, Lordship.
Very much grateful to your Lordship.
ওগুলোকে ঠিক করে দিও ওটা ফাইলটা পাঠিয়ে দিও আমার ইয়েতে না হলে
Lord, what has happened? I am at fault, I know, my lord. On 2 occasions, my lord, we were given directions to file, put in the requisite for special messenger cost, my lord, which we could not. If your lordship can kindly.
Well, last 2 days we don't have that. Go before the next subject.
Any further mention? Item number 1.
Item number 1,
Under bill in connection with Arbitration.
Dr. Chaudhary will be appearing this matter, Lordship. He is in court number 2, Lordship. Kindly short pass over.
First matter possible.
May I pass?
Matter 2.
Yes, what?
Matter is running, Lordship. Bring for short pass over, Lordship, please.
The criminal appeals pass over. Very well. Let it be passed over.
Lordship, I'm grateful.
But ask him to be here immediately.
Item number 2 under mandamus application.
Lord, I am for this statement. Lord, I appear for the.
Then I am for the order number.
My lords were pleased to hear it like before yesterday. This is in respect of a non-renewal of my license.
Yes. Yes. Any
Look, I have-
further submission?
Yes, my lord, I have taken instruction from DM Alipurdwar. The nature of land is, my lord, dhaba. So they have to first convert it into petrol pump, then, my lord, the license can be granted. So
No,
they
no.
should proceed with the conversion, my lord. The petitioner.
No.
Actually, petitioner cannot convert it, my lord, because the leasehold right is with the BPCL at present. So they need to convert it into, my lord, they have to approach the Malik, the landlady, my lord.
No. What is the question? Today the landlady will not say that when she entered into a lease with the Numaligarh refineries, it was very much known to her that the oil refinery will may use it for even retail outlet.
Yes, my lord, that she knew, but it was the duty of the refinery to initiate the proceedings for conversion, my lord, and with the help of the landlady. But they did not convert it that at that moment, my lord. And subsequently, the leasehold right went with the BPCL. They also did not proceed with the conversion, my lord. Now the main problem is, my lord, when the nature of land is dhaba, it is difficult for the authorities to issue license for petrol pump, running petrol pump, my lord. So we are struck there at that point.
So, is this the first in the history?
Lord, how dhaba can be?
Is this the first in the history?
Which classification of the land is required to operate a petrol pump?
Petrol pump.
Petrol pump. Oh, it has been included in your Land Reforms Act.
Yes, sir.
That classification is included.
Which provision?
So that to run a specific.
It will different land reform act আছে land reform manual টা আছে এখানে
Manual coming online.
And what your DM was doing since 2006?
My lord,
Granting me license, my lord.
earlier it was
Granting
offline.
me license. Till 2018, I had license.
My lord, earlier it was
2019,
offline mode, and my lord knows that how it works. Now they have
How
obtained
it
the
works.
license. Now
What kind of
since it
insinuation
is,
has been made, my
my
lord?
lord, a mistake which has been made in 2006 cannot be repeated at 2025. It cannot be repeated, my lord. And it is not a fault of the authority. We are asking a single paper that is the land paper. Provide us, let them take it from the BPCL because they are the leaseholder.
2006 থেকে চললো আর
Now suddenly DM bill.
ইনিশিয়াল লাইসেন্সটা হচ্ছে দিল আর রিনিউয়ালে গিয়ে
It was renewed. My lords have been pleased to see that the first lease by the landlady was for the purpose of setting up a petrol pump. Now, when NRL assigned it to BPCL, it assigned along with the structures and the machineries of the petrol pump.
Show us from the schedule.
Yes, fine.
ল্যান্ড ম্যানুয়ালটা নেই এখানে, সবুজ রঙের যে বইটা ওটা নেই। ল্যান্ড রিফর্মস অ্যাক্ট, অ্যাকুইজিশন দিয়ে হবে না।
No, no, reforms acted on the name, my lord.
Land manual.
Land manual.
My lord will kindly come to.
No one has a land manual.
Manual, my lord. I've just sent my the bar has. My lord will kindly take up page 169 of the application for stay.
169.
Yes.
Now, this, my lord, is the deed of transfer and assignment.
Just a minute. 169.
This, my lord, is the deed of assignment by Numaligor or NRL to BPCL.
Mr. Ghosh, we are overhearing something. Tell me, as a not as an advocate, if you were the landlady, would you allow the conversion? Because it is.
Since Millard has asked me about this, Millard, off the record, Millard, the landowner and the license holder are relatives.
Maybe.
And there is a family dispute.
Maybe don't look into that
Now,
yes,
aspect.
my lord.
Where was the original lease? Original lease?
Original is, my lord,
The landowner is not cooperating.
is at
With
page
He's
156.
getting the conversion done.
156.
Yes.
157.
Starts at 157. Sorry, 157, not 156. I stand corrected. Now 158. Now important is at page 159, my lord.
Just a minute, just a minute.
At 159, my lord, the second paragraph. May I place it?
No. Schedule is in the parent lease, parent lease.
Parent lease, my lord. Here, my lord, it is the use of the land has been defined.
Which
For-
one?
At
Which one?
page 159. Kindly see, I'm placing.
Arbitration.
And together also with full and free liberty to the lessee to use the demised premises as a storage depot or a service station for the purpose of selling or otherwise dealing in of receiving, storing, treating or handling for distribution of petroleum or any of its products, motor accessories or any other trade or business and other lawful purposes. Now, my lord, the third paragraph. And also together with full and free liberty to the lessee to erect and maintain in the demised premises all manner of equipment, plant, buildings, machinery, tanks, godowns, pumps, filling sheds and other structures, fixtures, appliances and facilities. Next paragraph, my lord. And together also with the right to construct, lay and maintain over, along and under the demised premises one or more pipe or pipes or pipelines of such length and diameter as may from time to time be required by the lessee. So this was specifically for the purpose, my lord, of setting up a petrol pump. Dealership can be appointed, it was also given here. Now, the schedule which my lords had asked me to show, which is part of the agreement, my lord, between NRL and
My lord, if my
BPCL,
lord comes to
which-
page 164, para 8,
which my lord says that the second schedule
164,
says
para 8.
that along with all immovable assets of NRL situated.
Just a minute, just a minute.
Sorry, I'm sorry. কোনটা বলে কাম শুনুন।
Para 8, 164, page number 164. The liability card ছিল ওটা।
Is what does it?
My lord, all the taxes, charges, assessments, including the non-agricultural assessment and outgoing whatsoever imposed or charges upon the lessor was responsible for it, my lord.
Who?
The
The superior landlord.
the refinery, my lord.
Yes.
So they have not performed their duty. They have not performed their duty.
Who are you? Who are you?
I'm
You are
the
the
landlady.
district
No, you are not the landlady, you are the state.
No. I am the state, my lord, but the landlady.
Why are you holding the brief of the landlady?
I'm not holding the brief of the landlady. I'm placing it because, my lord, the conversion, the main conversion with the help of the landlady, they should have done. They have not done it. And now they are not placing it.
It's not required. Why did you then grant him the license?
Yeah,
My lord, that was
the state has allowed the person concerned to operate a petrol pump from that land since 2006.
my lord.
Suddenly you raising this technical ground. Suddenly.
My lord.
Your action will give a legitimate expectation to the people. You cannot deny that, sir. Your conduct, your action. So you have allowed for decades. Now suddenly you realize that the land has been recorded as Thaba. You are not permitted to operate a petrol pump from that land.
Well,
only on the ground that it has been recorded as Thaba.
My lord, now allow me, my lord. From 2006, Bharat Petroleum, BPCL was helping the petitioner to get the license. They were producing the rent receipt and everything. My lord, kindly allow me. BPCL were providing the rent receipt and everything to the petitioner, and they were applying before the authorities and getting the license.
There is a connotation called transgressing into jurisdiction.
Well, when the first writ petition came, that time when the order was passed by this honorable court, trial judge, that conduct an inquiry, pass a region order, during that period, my lord, it came to the knowledge of the authorities that they don't possess any paper. And BPCL denied to give any papers.
Sir, the difficulty is that you are the district magistrate. What jurisdiction you are exercising? You are exercising a jurisdiction, quasi-judicial jurisdiction vested upon you by the statute. Now today, what is before you? Renewal. Now your predecessor in interest, whoever may be, has granted the permission. It is not a case that the pump was not operating. Now the documents are very clear. Landlady had granted a lease to Numaligarh for 36 years. The lease is still up to 2036. Now today, during the continuation of the lease, the original lessee, Numaligarh, has assigned its residual leasehold interest on and in respect of the land to Bharat Petroleum. Bharat Petroleum in turn has given the appellant a license to operate a retail outlet. Now the license is there, but license is there, and they were operating a retail outlet. No dispute. Now today, when they go for the renewal, an objection is raised by the landlady. Now, the landlady did not raise any objection when the initial license was given. Now, today, the landlady raises an objection and says that, look here, it is dhaba, it is not a petrol pump. And on that basis, you have restrained yourself by passing a reasoned order. The court has not gone into the court while the court had passed the order. The court did not frame the
Kindly, man.
court did not frame the issues.
Kindly come to page 250, man. Once, man. 250. My lord. Page 250. How the jurisdiction of the district magistrate came, this order will speak for it, my lord. In compliance of the order passed May.
ECL seems too interested not to the.
Yes. This makes something different.
Yes, I'm
Lord,
grateful.
how the jurisdiction of the district magistrate came, this query fell from your lordship proverb.
See, the
That's why I found there is no
where is the
nothing suggests by Mr. Bhattacharya that BPCL is too much interested in helping.
where is the order directing the magistrate to pass a reasoned order?
My lord.
Then we will go into it.
My lord, that your lordship kindly comes to page 238. My lord, this is the order passed by the honorable single bench in the first writ petition. 238.
238 operating portion 241. Para 3.
From 239, my lord. The third paragraph.
Yes.
239, third paragraph, my lord. Oh, may I place the entire order?
Yes.
From 238. And the petitioner moved this application under Article 226 of the Constitution of India upon receipt of a communication from the Bharat Petroleum Corporation Limited with regard to a proposed cancellation in case the petitioner fails to renew the license with regard to running of the petrol pump. It is submitted by the petitioner that the renewal of MSHSD license in respect of the business was due since January 1st, 2019, and the same was not been granted by the District Magistrate Alipurduar due to certain non-compliances. Such non-compliances as communicated to the petitioner by the District Magistrate Alipurduar by a letter dated 5th of January 2022 are quoted below. A. Copy of the trade license issued by the respective Panchayat Samiti valid up to 31st of December 2022. B. Copy of the Khutian number 181 and 550 as shown in selling license. C. Land conversion certificate as a petrol pump. It is submitted by the petitioner that with regard to non-compliances of serial number B and C, the petitioner has been taken appropriate steps before other authorities. The complaint is with regard to the non-grant of trade license by the Panchayat Samiti. The petitioner relies on several communications from the District Magistrate Alipurduar to the Block Development Officer Madarihat and Executive Officer Madarihat Panchayat Samiti, by which the District Magistrate has categorically directed the Block Development Officer and Executive Officer of Madarihat Panchayat Samiti to take urgent steps with regard to the grant of trade license to the petitioner. Upon considering the records, the court is satisfied that the Executive Officer Madarihat Panchayat Samiti has failed to issue the trade license. The application has been kept pending. Neither has the trade license been allowed, nor has a decision been taken rejecting such trade. Thus, this court is of the opinion that the authority cannot sit tight over the application. The concerned block development officer and executive officer of Madarhat Panchayat Samiti must immediately take steps with regard to the prayer of the petitioner for grant of trade license. If the authority finds that the application is in order and the petitioner has fulfilled all the criteria required for grant of such license, the same shall be granted within 3 weeks from the date of communication of the order. If it is found that the state authority that there are some deficiencies and non-compliances, the same shall be intimated to the petitioner within 3 weeks from the date of communication of this order, and upon the petitioner fulfilling such requirements, the trade license shall be granted within a week thereafter. Once the trade license is granted to the petitioner and the other requirements as indicated by the district magistrate Alipurduar are fulfilled, the district magistrate Alipurduar shall take expeditious steps for issuance of HSD license. And thereafter the trade petition was disposed of.
Then what happened?
Then, my lord,
Trade license granted. Trade license was granted.
no, trade license was not granted by the Panchayat.
Panchayat Samiti. Have you challenged that?
Which one? No, thereafter, my lord, the hearing was done by the district magistrate.
No. See, two issues. Trade license, the district magistrate is not granting the trade license. The trade license is by the Panchayat Samiti or the local administration. Local administration. Now, if that has not been granted,
Yes, my lord.
then your right to operate a retail outlet does not fructify, because having a valid trade license and other requisite qualifications, you will be granted the
HSD license.
spirit license. Now, if you don't have the trade license, it is a infructuous exercise, because you are.
No, 2021, thereafter it was applied online and we are granted
Which one?
the trade license.
That is what we are asking for. Do you have a valid trade license as of now? Where have you said so?
Just give me a moment, my lord.
আচ্ছা 251 এর রিফ্লেকশন আছে জিএমআই অর্ডার যা ডকুমেন্ট সাবমিট করেছে অপটেন ইলেকট্রনিক
Yes, obtained electronically. I must now thank Mr. Kosh.
but there is a defect
252,
also.
my lord. 252.
There is a defect also. Withdraw your.
So trade
No,
license,
thank you.
trade license is there.
Trade license is there.
Not obtained from a proper authority.
Yes. Now the question comes proper authority. There is a portal, my lords know that now since 2021, everything has to be applied online. Now it was applied online and generated. Now comes the question of the
See,
proper authority.
have you seen few days back a person has been arrested from Kagdi. He was generating fake birth certificates for age proof to get passport. The OTP was to come to the mobile phone of the Panchayat Pradhan. Now he had manipulated it. The OTP was coming to his number. He was feeding it and he was generating the birth certificates. So in our country, it is very difficult to rely upon anything unless you follow the Shakespearean idiom that seeing is believing.
We have seen that. Now what happened is we filed an application under the right to information. Like my lord, I'll trouble your lordship once with page 61, 261. Now here, my lord, one was the query that is there any provision to opt or choose to change authority, that is Gram Panchayat or Panchayat Samiti, in respect of an application made online. The reply, my lord, which came, which is at page 264, says no. So therefore, my lord, the applicant does not have the option to choose which authority will grant. My responsibility is to apply, and whether it is granted or not. If it is granted, my lord, then I have to presume that it has been granted correctly. So that defect, my lord, which the district magistrate has pointed out, if at all there is any defect, my lord, that is also outside my control.
Very good.
Then what happened?
Then, well, we got the trade license, but thereafter nothing. Trade license is at, sorry, madam, page 260.
What is the proof that you operated the retail outlet on the basis of that spirit license and trade
The
license?
earlier trade license, my lord. That proof per se, my lord, is not here. But that has not been disputed by BPCL anyway.
Who is BPCL? BPCL is more interested
License.
if your license gets cancelled. If they are in a position to cancel your license, they will induct me with a higher charges. They are interested.
Except for the
difficulty is that according to our guideline, if for regulatory issues, if a retail outlet is closed for a particular period of time, we have to take a decision because there is a quarterly audit. We
That
found
is
out
true.
that this retail outlet is not operational since long, therefore we are under compulsion to initiate the process of cancellation of the agreement, which prompted them to file the first recognition.
So see, Mr. Ghosh, the difficulty is that there is a term called force measure. Now,
Right.
force measure.
Right.
Now, today, the petrol pump owner cannot catch hold of the magistrate and ask him to grant the license of the Panchayat Samiti. So they are dependent on it. Now, today, let us take the matter from a particular point of view without going into the legal technicalities. Today, you as the licensor, you will see that whether he complies the requirements, statutory requirements. Now, the licensee says that I had applied for renewal. Now I am not being granted the renewal.
No, but that
It
is the
is-
reason, Millard, the
he-
process of cancellation was.
No, he can be,
Cancellation was
he can
ultimately
be,
not done, it's still pending.
he can be,
To grant him an opportunity so that
he can be penalized if he had not applied for renewal. But once he had applied for renewal, it is for the authority either to grant or reject.
But since nothing was happening, Millard.
The writ petition was filed.
Repetition was filed, the cancellation was also not given any effect.
Now today the
In any manner.
Panchayat Pradhan thought it fit that the petrol pump will not inure to his benefit, so he rejected it.
That is, Millard, in between him and the Panchayat. Millard, BPCL is only concerned whether all the statutory clearances are there, so that it can operate.
Mr. Ghosh, you are the licensor.
Millard, in that jurisdiction,
You owe certain responsibility also.
Millard, let them show from the agreement that I have breached an obligation which was.
No, not breached an obligation. You have also an obligation. You have an obligation to the extent that what land, on which land, because the land is not his. On which land?
Neither BPCLs, we are only the lessor.
No.
It is the lessor who is the landowner. He has.
No,
to take
on
steps.
what land? On what land you have granted license to operate a retail outlet? If we go by your submissions that the land was dhaba, so a license, then you have also committed fault.
Maybe, promissory estoppel cannot operate against the law. If the law says it has to be converted into a petrol pump, it has to be converted.
No, it is temporary. Conversion
Yes,
means for personal use. Yes, state can claim the settlee, that means a riot shall use the land for
For a
which
particular purpose.
for the purpose it was settled to.
It was settled.
Yes,
My lord,
that is
sorry,
it.
sorry.
But here fact remains is that the state has allowed a person or a company to operate petrol pump from that land for decades. For decades.
And also, my lord.
Now, Now, no objection from the landowner cannot come because landowner has already executed a lease deed. Says lease deed is still in force till 2036.
Subject to corrections.
36.
Subject to correction, so far as the selling expense is concerned, what are the documents required? That is stipulated in the Government of West Bengal Directorate of Consumer Goods notification itself. So beyond the notification, the district magistrate cannot go, and what has been sought for is accordance with the notification. No objection, rent receipt, conversion, whatever it is.
The application is made for it.
They have not challenged this notification. That is this
When
requirement,
one
sir.
owner is granting lease in favor of any person, empowering him to operate a petrol pump from that land, whether further
that
no
is-
objection is required.
That is not a case made out neither in the.
The lease
written
deed
or-
itself will be treated as a no objection.
That is not a case made out in the, written. That's not an usual.
Forget about that, whether the
Let it
lease,
satisfy the other criteria first. Land conversion, trade license.
rent receipt petitioner is not proper custodian of the administration.
Let him cross the
Kindly,
hurdles.
kindly,
Hurdles first.
before my lords sees that, my lords will kindly come to page 188 of the stay application once. কি দিলে বলি?
EM is struck by this
Land
notification
receipt,
dated
no
the 2nd of
objection.
November 2018.
Valid trade listed.
For any renewal, this checklist, online checklist, my lord. You cannot proceed. Previously, it was offline, it could have been done.
Kindly, my lord, sees page 188 once. That is the agreement between me and the and BPCL, where it says that the said premises and the said facilities shall at all times during the continuance of this license remain the absolute property and in sole possession of the company.
Mr. Bhattacharya, do you want to use additional documents?
My lord, here, since it has fallen from your lordship, I'll be candid, my lord. A lot of additional documents have been placed before your lordship, which were not before the honorable single judge. I'm sorry.
Problem will be solved if you approach the owner.
BPCL.
ওনার কি দেবে নাকি হাত
And then, my lord, that agreement
Now
also says,
relationship is bitter.
and this agreement
Hence
also
problem
says
popped.
that the company will.
Beyond the records, Miller, even the officers of the BPCL has made several attempts for a reconciliation. So that both of them can come together, all this can be sorted out in one.
No, I am, my lord, not connected with that. It is between BPCL and the landlord. And the agreement, my lord, which I just referred to, it also says the company hereby covenants and agrees with the licensee as follows: to obtain its own name and renew from time to time at its own cost a license or licenses for the storage of petroleum products upon the said premises necessary. It is the company's, except what I have understood, except for any specific law or statute which puts a onus on the licensee to obtain any license. Every other license and permission, my lord, will be obtained by the company, which is BPCL, which is at page 190, my lord. So BPCL, my lord, cannot shrug off its responsibilities here and then put the entire onus on me. Kindly see, my lord, page 190.
একটা বাজেট
Our problem is we are struck by that notification. And they have not challenged that notification. They have not challenged that notification. We are struck by that notification because the requisite say that we required these documents. And until that is provided, rent receipt can be provided by BPCL to the petitioner and they can submit it before
One
us.
thing, my lord, I'm sorry, I should have brought it to my learned junior as well. At page 272, my lord, kindly see. This is grant written to the regional manager NRL by TM 26th of October 272. This is grant of NOC. This is to inform him that that the undersigned hereby grants no objection certificate for storage of petroleum products class A such and such, my lord, at this my lord. subject to fulfillment of terms and conditions of West Bengal Fire Service as laid down in memo number such and such.
Yes,
Oh,
so
I think
this
it's fire.
semester had permitted 2005.
This is
And
in regard to
that
the fire.
permission, why that permission should not be treated as a permission granted till 2036.
My lord, every time, if our application is made for renewal, we are bound by that notification.
Yes, of that.
My lord,
Licenses, my lord, for running petrol pump should be taken from small oil companies. Where the revenue matters.
Take down, take down.
my lord, kindly grant us leave to file affidavit.
It is submitted by the respondents that certain additional documents which have been used, which were not used before the learned single bench, has been incorporated in the stay application. The respondents intend to deal with such documents, such additional documents, by filing an affidavit. The petitioner at the same time submits that they intend to disclose some further document. Let the supplementary affidavit, the petitioner is permitted to file a supplementary affidavit. To bring on record the any additional document they intend to rely upon within
Within, my lord, 10 days.
within 27th June 2022. The respondents shall be entitled to file an affidavit in opposition dealing with a composite affidavit in opposition dealing with the writ petition as also the supplementary affidavit that may be filed by the appellant. Let such affidavit in opposition be filed by the respondents by 11th July. Let this matter be placed before the
Leave to file affidavit in reply.
the petitioner shall be permitted to file a reply dealing with the affidavit or affidavits that may be filed by the respondents.
My lord, one indulgence.
The
Can the time period be extended? Because on 12th July, maybe the circuit bench inauguration. will
I
take place.
giving you 11th July.
Yes, my
12th
lord.
July is subsequent.
Subsequent, yes, ma'am. আর আমরা কি করবো? আমরা তো গিয়ে attend করবো শুধু। আমাদের কিছু করার নেই। তোমার কি আমার বিক্রমের তোর প্রবলেম হতে পারে, বিক্রমকে সবাই ডাকে, সে তো কোনো কথা। তুই নিজেকে বিক্রমের জায়গাটা পাচ্ছি।
ঠিক আছে 4th জুলাই করে দাও।
4th July।
না না ওইটা 4th জুলাই করো, ওই একটা ওই 27 তারিখের জায়গায় 4th জুলাই করে দিল।
হ্যাঁ 27 তারিখের জায়গায় 4th জুলাই।
হ্যাঁ
আর ওটা যেমন আছে
না 27 তারিখ সরি 27 তারিখটা ঠিক থাক, 27 তারিখটা ঠিক থাক, ওটা ও দিলাম 11th জুলাই তো। না 11 জুলাইটা ফোর্থ না 11 জুলাইটাকে করে দাও 18 জুলাই
Deeply obliged.
18 July.
ইয়েস না তারপরে এফিডেভিট রিপ্লাই বাই July 31st. ঠিক আছে matter to appear before the circuit bench immediately after available immediately after 31st July subject to its convenience.
Leave to mention, my lord.
Appear, it will appear directly.
Grateful, my lord.
Deeply obliged.
আচ্ছা ওখানে একটা সেন্টেন্স লিখে দাও since we have permitted the respondents to deal with the documents the filing of an application under order 41 filing of an application analogous to the principles of order 41 rule 27 of the Code of Civil Procedure 1908 in short CPC by the appellant is dispensed with.
Great.
না না ডিসপিউট অফ এফিডেভিট সেট করে আসুন
Grateful, my lord.
Deeply obliged.
Yes.
Lordships, in this case, the accused was previously on bail and now he is in custody for more than 6 years. Punishment is prescribed for 10 years, out of which more than 50% is detained in custody. So the judiciary, this
What is the offense?
offense is the section 6 of the POCSO. Lordships is to be considered that after releasing from the bail, on each and every date, this accused is appeared at the time of the trial. Trial date on 14th/11/2024 he appeared. 27, 28.
Why was the bail cancelled? Why was the bail cancelled?
No, bail has not been
After
cancelled.
conviction,
He
he
is
was taken into
convicted.
custody.
He was convicted and taken into the custody. And
Pre-conviction bail.
pre-conviction.
Pre-conviction bail. So after conviction, he has been taken into custody.
Yes, yes.
Now see, the 2020 judgment is the bone of contention because pre-conviction and post-conviction, there is a difference. Now, how do you come under it?
So Lordships, now we come into the merit of the case.
Yes.
Lordships, this is the copy of the evidence.
See, you show us the you show us the compelling circumstances for which the sentence has to be suspended. Because if we have to go into the evidence, then we will be transgressing into the final appellate jurisdiction.
Right.
Because that has to be considered over there. Your case is that 10 years have been prescribed. Now, 6 years have
elapsed.
So your ground at the highest may be that there is no likelihood of the criminal appeal to be heard.
Yes.
Now, in that situation, how many times you had asked for adjournment?
No, sir. Never. I never made any prayer for adjournment.
The paper book is ready.
No. Last week it was last week.
Last week that is admitted for condonation of delay.
Yes, thereafter this.
We had a yes. See, last day you were moving the bail application. We gave you another opportunity to earn something.
Lordship, so for the merit of the case, the age of the victim girl that has not been exhibited. The birth certificate has not been exhibited, and the meteorological exam
না না রেগুলার করতে করতে ছাড় যাবে মাঝে মাঝে আপনার চিন্তা খেলা দিতে পারেন ওই ধরে রাখুন আপনি ফাইলটা নিয়ে কাজে রাখবেন তাই আমি সেই জন্যই বলছি ফাইলটা রেগুলার করবেন ফাইলটা যেন লিখে রাখবেন।
যা হয়ে গেলে তার ইনভেস্টিগেশন Yes.
Lord,
Yes.
Lord, next item number 3, Lord.
Yes.
Is appearing for the Lord plaintiff respondent, my Lord. Mr. Chattopadhyay is appearing on the other side. I think he was there.
Item number 3,
Yes.
under application.
You are appearing for whom?
I'm led by Mr. U.S. Menon, your lordship.
Well, I'm for the appellant respondent in this applicant.
My Lord, may I-
Mr. Menon, you mentioned it for
Yes.
instance, you said that though the time had been granted, no affidavits have come.
My lord,
My
that is
lordship-
why I was praying, my lord, for
My
a
lord-
short extension of to file affidavit, my
My
lord.
lord,
It is ready, my lord. It is to be affirmed, my lord, within day or two, my lord.
Well,
Just,
I
my
think-
lord, let the matter appear in the next circuit bench, my lord. In the meantime, my lord, affidavit shall be served, my lord, upon Mr. Menon.
My Lord, I take lordship. May I
Then
submit?
affidavit in reply?
My Lord, may I submit, my Lord? May I submit? This application, I don't think there is much scope for filing any affidavit in opposition. Be that as may, my Lord, I am not standing in the way. Now, this matter has some checkered history, my Lord. My Lord, what has happened, my Lord? My Lord, I obtained a decree for mean profit, and for 25 years they were in a wrongful occupation. And my Lord, there was an order. Your Lordship kindly come to the order dated, my Lord, 2nd August. My Lord,
No,
there-
My lord, that
see,
Yes.
you said while you mentioned the matter that they have deposited some 29 crores.
no,
Let-
39 crores.
39.
39
You
crores
want
we have
to
deposited.
you want to withdraw a portion thereof by
Lordship,
giving a bank guarantee.
Lordship.
Now that application has been kept in abeyance because the appeal is pending.
No. Because
Yes,
this
my lord,
that
that is my lord.
application, that
My lord, we
application,
have
may I submit? That application was taken up for hearing on 28th April. Now, my Lord, at the instant, my learned friend prayed for time to file affidavit in opposition. The time expired on 15th May. Now, the matter was directed to appear 6 weeks since. That period is also over. Now, my Lord, I was in this application, my Lord, I am praying for a release of a portion of the amount, my Lord, against furnishing a bank guarantee, my Lord, to the satisfaction of the Registrar General. That is my, I don't know what
No, my lord.
objection they can have.
No, my
They
lord.
are not going to be prejudiced.
My lord, this submission, my lord, what I respectfully submit, my lord, this submission has been made when the appeal was admitted. Now, my lord, that was not entertained, my lord, only direction was given. Now, my lord, we have got the intimation from arrival of the lower court record on 9th, my lord. We are in the preparation of the paper book. It will be filed, my lord. There was direction for to file it within 6 weeks, my lord. It will file, my lord, within a week or two, my lord. Then immediately after filing of the paper book, the appeal will be treated as ready. My lord, let the appeal be itself be heard out.
Mr. Menon, what was the rent?
My Lord, rent was very minimum because it is, this was,
rent, what was the rent?
rent was very minimum because the commissioner, my Lord, the chartered valuer.
No,
My Lord,
what amount? What was the amount of rent?
My Lord, rent was, my Lord, it was enhanced from time to time because there was a lease for 15 years.
No, at the, what was the last paid rent?
Last paid rent, my Lord, it was very, I mean, I can't, it's not there at the moment, my Lord. It was very minimum. My Lord, I can tell you, Lordship.
What was
My
the
Lord,
last paid rent?
Your lordship, I do not have it with me.
No, I tell you, Lordship, may submit.
See,
Now, my Lord,
Mr. Menon,
Lordship.
we go by the principles of Atmaram.
Yes.
Super gas.
Yes.
See, up to the date of the decree.
Yes.
You are entitled the rent.
No, my Lord, what happened in this happened, they did not pay. Now, thereafter, what happened? There was an appeal. Now, appeal court directed to pay at the rate of 50,000 rupees per month. Now,
Yes.
what, my Lord, in the meantime, my Lord,
as per, pursuant to the order of the Honorable Court, this my lord, the chartered valuer, Talbot and Company was appointed to go, to ascertain the, my lord, the mean profit. Now,
See, Mr. Menon, the things has to be balanced.
yes,
Now, there is a decree for mean profit,
Lordship,
against which they have deposited 39 crores.
Lordship.
Now, let us have a practical view. Because if we allow you to take away the money with the bank guarantee, then at the end of the day, if he succeeds,
No,
it will be.
No. May I interrupt?
It will be a multiplication of judicial proceedings to get the money back.
No,
Now, what we can do, so far as from the date of, say, notice up to the date of the decree, you will be entitled to the rent.
No,
because I do not know whether this is a transfer of property act or
yes, transfer of property act. Kindly hear me for a moment. Hear me for a moment. Now, what happened? The commissioner chartered valuer, appointed by the court, my lord, ascertained the mean profit. Now, the mean profit to that was confirmed after taking evidence. The matter went up to Supreme Court. Now, that was confirmed. My lord, the Honorable High Court upheld the valuation. Then Supreme Court also upheld. Now, as per the valuation, my lord, my lord, the valuer has, my lord, ascertained the valuation. Now it comes.
My lord, my learned senior film, my lord, is, my lord, entering into the merit of the appeal.
Very well.
My lord,
Now let
kindly grant me some time, my
file
lord.
an affidavit in case they want to file an affidavit.
Yes, my lord, kindly extend it, my lord, for my lord 2 weeks, my lord. In the meantime, my lord, we shall serve the advance copy to Mr. Menon, my lord.
Just a minute. Mr. Menon,
Lordship.
In one of your matters, while I was in the bar,
Lordship,
Siliguri property,
yes,
Siliguri property, WBACB.
No, yes, your lordship will kindly, that this is not that matter. This is that was adjacent property. That was Singania Corporation. My lord, your lordship was referring to that other matter, Singania Corporation. And that was also, my lord, there was a final order. Now, that was a writ petition, my lord. Now, in this matter,
that was land acquisition case.
Lordship, that was a land acquisition. Now, in this case, mean profit was ascertained. The matter traveled right up to Supreme Court, upheld. Then Supreme Court gave them another opportunity to, my lord, seek other remedy. That means by filing an appeal or something. That is how they have filed an appeal. Now, my lord, 25 years they were in wrongful occupation. And anyway,
if the mean profit has been, say, confirmed by the Supreme Court,
yes,
how is this appeal coming?
No, Supreme Court gave them liberty to, my lord, seek other remedies, because first that was not a final order. The trial court, my lord, confirmed the commissioner's report, and against which they filed a revisional application before the Honorable High Court. Honorable High Court Justice Sanjeev Banerjee confirmed that order, against which they went to Supreme Court. Supreme Court said that it may seek other remedies. Other remedy means after determining, because this was already determined. Now, my lord, they have filed an appeal on some other grounds on the same time. Now that, my lord, in any case, my lord, since my learned friend, my lord, is seeking extension, my lord, I'm not standing in the way, because they should be given an opportunity to. They should have filed a opposition by 15th. This is a very short application, and I'm only seeking a order for release of a portion of the amount which was deposited by them, my lord, against furnishing security. As lord, at the cost of repetition, I am just saying. So, lordship, kindly expedite the matter, my lord, if they want to.
No, we are hearing your application.
Lordship.
Application. So, in that, they have to file their opposition. They did not.
They have not filed.
Only, my lord, short extension, my lord, be directed, my lord. In the meantime, it is on the process, my lord, for approval. My lord, it will be done, my lord, within 7 to 10 days.
Yes. Take down. This is an application made by the respondent in the appeal for release of a portion of the mean profit already decided and confirmed to be released upon furnishing of bank guarantee. The appellant has objected to the release of the money and as such was granted liberty to file affidavit. Despite there being long passage of time, no affidavit has yet been filed by the appellant in respect of this application. In the aforesaid facts and circumstances, the time to file the affidavit in opposition by the appellant in this application is peremptorily extended till কবে হলো আজকে কত তারিখ 18
18
till 26th June 2025. The time to file affidavit in reply is extended till. Can you do it by 4th July?
My lord, I won't, my lord, my lord, Lordship, I'll be traveling, I'll be out of Calcutta from 3rd to 10th for some personal reason. So any date after 10th.
Because after 10th, then the next circuit will be over. Because next circuit is up to 10th.
My lord, I have some difficulty, my lord. That is a
time to file affidavit in reply is extended till 22nd July 2025. Let this application along with the connected appeal appear before the circuit bench available immediately after last date
2nd July.
22nd July 2025. It is made clear that in the event the appellant fails to file the affidavit in opposition within the extended period of time, no further extension shall be granted and the matter shall be and the application shall be heard without the affidavit from the side of the appellant.
May I submit one thing?
Yes.
Since your lordship is fixing the matter after 22nd, kindly instead of 26, my lord, maybe my lord on 30th, my lord, the vacation bench will be there. 30th June.
30th June or July? 30th June.
30th June.
Mr. Menon?
Lordship.
30th June.
I have, my lord, one interjects, my lord, one more thing. My lord, your lordship has been, pleased to direct the appeal also to be appear in the list along with the application.
Yes.
Now, there was a direction for filing paper book. Now, my lord, paper book has not been filed because there was some difficulty because the trial court records were incomplete. So it was sent back to trial court. Then it has now come back and the paper book was to be filed, my lord, immediately after sending a intimation to the appellant. That intimation they have received. So lordship kindly direct them to file the paper book.
Yes, my lord. I was submitting, my lord. On 9th, my lord, we have got the intimation of arrival of the lower court record, my lord. It is under process of, my lord, the paper being under process, my lord.
Mr. Menon, that is reason exactly we had directed the appeal to appear on the next day.
Lordship.
Yes.
Deeply obliged.
My name be recorded, my lord. I am given the chat box.
Yes.
Was appearing with Miss Acharya. Lordship.
Item number 4. And the Panama's appeal hearing.
Right, my lord. I am going to see detailed statement.
Yes. I'm appealing for the WBSC led by Mr. Sujit Shankar Kolel. Where is the state?
I appear for the appellant petitioner, my lord, in the second. Yes, your lordship. Expressed yesterday, my lord.
Yes, unless I hear them, because their appeal is against the whole order.
Yes, please, my lord. Appeal pending for 6 years now.
See, the situation is.
They were there. Writ of 2018, appeal of 2019.
See,
Who is appearing for the stay?
Mr. Thakkar,
Please.
your client will not suffer any great prejudice. Why I say so? Because if we are with you,
Please, my lord.
that interest has to be paid, the interest will be paid on the principal sum at a particular rate until repayment.
Please, my lord.
So you will be compensated. But see, look here, this is the situation.
No, this is very unfortunate. I'll tell you also why the difficulty is and why, my lord, my client is hard pressed, my lord, because your lordship knows these are industries. There's a bank loan. I am suffering interest at 18%. I don't get the principal from 2012. Monies are due since 2012, my lords. That is the difficulty.
Yes, Mr. Shah has come.
I'm grateful.
এইখানটা হ্যাঁ এনেকে বড় করুন।
These monies are due since 2012, my lords. And this is the third round of litigation now.
Yes, they have come.
Grateful to them.
Mr. Bormon, start your appeal.
ये उसका पेपर है ना আপনি ওনাকে আসতে দিন ওনার আপনি
এটা নয় অন্যটা একই পেপার বুকটা Act of 2020.
The application. They have perhaps not filed a paper book, but there's just a stay.
That is a problem.
Oh. They are not even filed. My paper book is there, but I am ready with their stay. The stay has all the papers, my lord.
Very well. Let us look into because see,
The papers are common in my paper book. They have chosen not to file paper book. There's a contempt pending. Contempt did not proceed because they said we filed an appeal. Appeal from a money order, no stay.
But so far as the judgment of Justice Nietzsche in respect of contempt and appeal, have you considered that?
No, my lord, I didn't have occasion to, but now
Look into it. By keeping the appeal pending, you cannot frustrate the
you
contempt.
cannot, my lord. But that is how what has happened in this matter. They were directed to pay the money within 6 weeks. 6 weeks has long gone from the order of the learned single judge, the writ court, my lord. 2019. Money not paid till today. Let him press his appeal, my lord, whatever is there.
You have not received the
Nothing, not a dime. Money is outstanding since 2012. Under an incentive scheme to set up the industry. I set up the industry. I can't do anything.
Matter was pending before the principal.
no problem. You place,
Yes.
you place the
The
order.
problem is whether you will be able to present your case.
Yes, sir.
না impugned orderটাই দেখাক না কি ভুল
Yes, impugned order, come to page 211 of the paper book.
My lord, or my learned friend's stay application, my lord, has
Yes.
the full papers. Their stay application, the order impugned is at page, I'll tell your lordship, my lord, 224. First few pages are the certified copy, the stamp, etc. Your lordships take 220, annexure D is a stay application.
The application can 1259.
Yeah, my lord. Yes, please, my lord. Can number 1259 of 2020. Your lordships have annexure D at page 220, please, my lord. That is the last annexure to his stay application. The documents are the same in my paper book and in the stay application. There's no new document. I have got the corresponding page numbers also written. Just in case.
স্টে অ্যামেন্ডেড স্টে কি হয়েছে ঘেঁটে চচ্চড়ি হয়ে গেছে।
It was previously nomenclature was wrong. It was filed in the name of Wisdom State Distribution Company. They were not the applicant. Applicant
is the general manager, officer in charge, District Industrial Center, Siliguri.
Page 274.
My lord, 220 perhaps, my lord.
225, the
Operative portion.
no,
224.
224, my lord, it starts.
Yes.
yes, Mr. Verma.
See, where is the flaw? Scope of intra-court appeal is very limited.
not. The main, our main contention is that this subsidy was given as per the scheme as laid by the state government and as per page 60 of our stay application.
Yes.
Yes.
Clause 10. Waiver of electricity duty and subsidy on the electric charges.
Yes.
An eligible micro unit enterprise for its approved project will be entitled to waiver of electricity duty on the electricity consumed for the production operation activity for a period of 5 years from the date of commencement of the production operation.
Yes.
And as per clause 10(3), an eligible micro or small scale unit enterprise will be entitled to reimbursement of electricity charges to the tune of at the rate of 30% of such charge paid for the period of 5 years. So there is a 30 plus interest, that is 40% that is admitted for such charges paid for a period of 5 years. That period is limit for a limited period to encourage.
This is like tax holiday. Incentive schemes are like tax holiday.
Yes. Just to encourage these small scale units and
On fact, where
and-
did the
this,
single judge go wrong?
And the subsidy as per this policy was strictly for a period of 5 years, and that too reimbursement of 40%, that will be 40% on the electric charges. Now there are cases that, and this is not disputed from the order sheet or on relevant portion. And at page 232, you will find that
Right.
230.
Yes.
and from 230 of the improved judgment, it will reveal that it was specific finding of the honorable thing in that point number clause 4. Subsidy on the energy charges for the period 2009 from 9/11, that is the period for which they are entitled as per the policy, 9/11/2009 to 8/11/2014. That is the period of 5 years. The subsidy at the rate of 40% was duly paid by the this industrial department to the petitioner as per the policy. This was paid. Proof was 35 lakh 061,512. This is not disputed. We have already paid this amount.
Show us the records.
This is admitted position. From the judgment also, it will reveal that this has been paid.
Then what is the where in the writ petition?
They are
আরে ওই বেরিয়ে না এটা গল্পটা হচ্ছে চার্জেস আজকে বাড়লো উইথ রেট্রোস্পেক্টিভ এফেক্ট। সেই রেট্রোস্পেক্টিভ এফেক্টে অনুযায়ী ওকে তো পয়সা দিতে হয়েছে। ও বলছে যে ভাই আমি যেটা 10 টাকা বিল ছিল সেই 10 টাকা বিল আমি পেমেন্ট করেছি, গভর্নমেন্ট আমাকে 10 টাকা দিয়েছে। এবারে রেট্রোস্পেক্টিভলি ওটা বাড়িয়ে 12 টাকা করা হলো। এই যে 2 টাকাটা, এই 2 টাকাটা হচ্ছে আমাকে দেয়নি। তো 2 টাকার রেসপেক্টে যেটা পাবো সেটা আমাকে দেয়নি। তো দে ওয়ার ওবলাইজড টু আন্ডার দি স্কিম। নাও এই যার ফলেতে ওরা ইয়ে করেছিল, তোমার হচ্ছে পিটিশনটা ফাইল করেছিল ওই এক্সেস অ্যামাউন্ট। সেখানে পয়েন্ট উঠেছিল যে whether they had actually paid that or not.
Paid that amount.
That's one of the points.
Additional
only
charge.
Now that has been clarified. The single bench has held that 25 lakhs odd is the money which is now payable by the
2.5 crores. 2.5 crores odd, my lord. Which is 40% of the revision.
See, you think of in crores. I cannot think. I only in lakhs at the highest.
They do not address me, my lord.
And the forthwith made pair 53 made pair.
Yes.
First writ of mandamus seeking cancellation of the reason order is such and such dated 18. Second pair is make payment of electricity / energy subsidy payable to the petitioner under such and such scheme for a sum of rupees 2 and 5 crores and all.
No dispute on this amount also, my lord. There's no dispute on period. The only dispute, and that is the only dispute which they can raise before your lordships also, is whether this money was paid or not. Whether this area in charges which was recovered subsequently by the licensee, whether I actually paid or not. I was asked to make a representation to the department. The department rejected my representation only on the ground that you have not been able to establish payment with money receipt. You are not showing money receipt, I am rejecting. Although the licensee has already certified that the payment was made. And they say that this was mandatory under the scheme, clause 10.3, that I was required to submit money receipt. So your lordship has seen clause 10.3. It is nowhere said that this is a mandatory condition that money receipt has to be given. The earlier practice was bank statements. They used to take certificate from the bank whether this payment has been remitted to the licensee or not. In the first round of litigation before your lordship, when I filed the first writ petition, this honorable court held that the licensee has certified payment has been made. So you make a representation to the DIC and they will consider it. After the finding of this honorable court, in the first round of the writ petition, that money has already been paid as certified by the licensee, still they refuse to release. Still they refuse to release. If your lordship sees the order of the first writ petition, please, my lord.
And it was stated one director, your director has certified that there is no due certificate
Yes.
shall be treated as a
Final.
such and such. I have
Your lordship has seen.
that date. take us to that portion. Most probably on director.
Of the licensee company. My lord, they sought confirmation from the licensee. My lord, may kindly have. The state sought confirmation from the licensee whether this amount has been paid or not.
Yes.
Page 168, please, my lord.
168.
Yes, please, my lord. 168. It's not a very legible document. My paper book has a legible copy, but if your lordship kindly sees their appeal, since your lordship is saying,
Yes.
documents are the same. Now, my lord, this is the state writing to the chief engineer commercial of the state of the licensee company. Then, my lord, kindly see. Mute kore din apni. Oh. Messrs. So and so.
Mr. Cole, some outside sound that's coming outside. Noise. Noise.
Now, my lord, they write it. Now, kindly see the date, my lord. 17 June 2015.
Yes.
They seek confirmation from the licensee. Messrs. So and so, who's the petitioner located at so and so, has approached this office for subsidy on electricity energy charges paid as per revised claim of energy charges due to redetermination of tariff by the distribution company under the scheme of 2007 for MSEs. The detail of energy-wise charges paid to WBSCDCL by the enterprise are mentioned below. Now, my lord, kindly sees the chart which they have prepared. From now, this starts from May 2010. The charge which was already there, column 2, your lordship sees what my learned friend said, 2.5 crores paid, energy charge paid as per monthly bill, and subsidy already approved or disbursed. So, my lord, the bill earlier was 9 crores 30 lakhs. 62,946. It stood revised. Now, my lord, kindly see column 3. Revised energy charge after enhancement of tariff by the commission, 9 crores 86 lakhs. Difference is, my lord, 5 crores 57 lakhs energy charge. Kindly see kindly see the heading. Amount of energy charge paid but subsidy is pending. And then details of orders for redetermination. So the next column, my lord, is not so important. It gives the order of the commission by which. So, my lord, these column 4 total adds up to 6 crores 25 lakhs 92,789 on revision. They seek this confirmation, and kindly see the next page, please, my lord. At page 169.
Yes.
The enterprise has paid amount mentioned in column number 2. So column number 2 is the amount, initial amount. Now kindly see the next paragraph. Now the enterprise has submitted claim to this office for incentive under the scheme on amount of energy charges which are paid due to redetermination of tariff mentioned in column 4, that is this amount. As per the order. In view of the above, it is requested to please confirm whether the unit or enterprise has paid these amounts, that is the 6 crore total figure, my lord, as energy charges as per statement include. In this regard, detailed statement is enclosed under annexure ABCD. Thus, this is urgently required for the purpose of sanction or approval of subsidy under the scheme. In this regard, your coin cooperation is solicited. Now, my lord, the licensee replied at page 172.
Yes.
Kindly see, my lord. So now the licensee replied promptly by its letter of June 2015. Kindly see the column now, the chart enclosures to this. And kindly see A and B, they've split it into 2 portions. And kindly see, my lord, amount, kindly see the 4th column now, my lord. Amount of energy charges paid. Licensee is saying these are the energy charges which have already been paid in both the columns. First, annexure A, annexure B, annexure C, annexure D.
Now, Mr. Thakkar, the main question is elsewhere.
Please, my lord.
You have read the Mofatlal judgment.
Yes, my lord.
Now, today, you are buying electricity at the rate of, say, 25 rupees.
Please, my lord.
Now,
on that basis, your production cost is also ascertained.
Yes, my lord.
Now, you sell the price, sell the product with some profit.
Yes.
Now, in the production cost, which is computed on the basis of the energy charges,
Yes, my lord.
which you paid,
Yes, my lord.
you have passed on the burden to your customers and client. If that be so, how are you entitled to the chargeback?
No, my lord, a chargeback as in, I'm sorry, my lord.
See, the issue over there was you have paid, you are charged with a tax quantum in Mavatla.
Yes, my lord. 5. Say, supposing at that time, my lord, it was 5 rupees. If I may
5 rupees.
5 rupees.
Now, on the basis of that tax quantum, you have already sold your product.
Please, my lord.
And you have realized the money.
Yes, my lords.
So, these 5 rupees, which was charged to you, has been passed on to your clients and customers.
In the factoring in the production cost.
In the factor. Now, how, see, plain and simple, if you look into this matter, the principal amount is allowed. It was, when it is allowed, if the principal is allowed, then the interest ought to have been allowed because I was out of pocket.
Yes.
And they have derived benefit out of the money.
Yes, my lords.
So, on that basis, the plain and simple equation is I am entitled to interest, which is your case.
Please, my lord.
Now, what will happen, because interest has been refused, but at the end of the day, if you look into that, because you are a
Commercial transaction, if your lordship is
production unit, you are
yes,
a production.
I'm a production. I'm grateful, man. Now, man, let's kindly appreciate. 5 rupees was the electricity charge when I produced the goods, and I recovered that as part of my factored that into my production cost, and I sold the goods at say 10 rupees. That 5 rupees is electricity, 2 rupees is manufacturing.
So that amount has been passed on, has been taken account into your
Grateful,
production cost
yes.
and has been
Accession of
passed upon.
price of goods.
Yes, please, my lord.
Price of product.
It forms part of my price of goods. Now, my lord, on that, they have already given me the incentive. Already. That 5 rupees which was there, I've got the incentive. Now, what has happened, my lord, after 3 years, when the tariff is revised, the production cost goes up from 5 rupees to 10 rupees because of the tariff revision. Retrospectively, my lord.
That is where I was coming to.
Now, my lord, I can't recover it from my consumer. He has taken the money.
Where you have made out a case.
Yeah,
that
made
case.
out that case.
No, my lord, that case with the greatest of respect is not required to be made out, my lord, because this is their absolute obligation to pay on the revision, and that is their admitted position. They are saying we will pay. Now the license is to certify whether you have borne the cost. I have to bear the cost. Otherwise, my lord, my supply line will be disconnected. Number one. No. Number two, the license.
Your argument can be like this.
Please, my lord.
Look here,
so far is already paid.
No.
Correct. Already paid.
So far as the amount,
yes, my lord,
which I am entitled to as an incentive, I have taken into account the amount which was paid by me to the electricity company on the basis of the prevailing charges at that point of time.
Yes.
So, whatever was the production cost, whatever may be, they have agreed and they have given me the incentive.
That's as per the incentive.
Now, when it was retrospectively fixed, because this happens because they go before the Electricity Regulatory Commission and get their tariff rate revised.
Yes, my lord.
Now, when this revision takes place, you will be finding in your domestic also.
Yes.
You are paying every month.
Some installment is added.
Some installment is added.
Yes.
Now, this amount which had been computed subsequently and made applicable retrospectively. I had no occasion to even take into account that amount
Yes.
in my production cost
Yes.
to pass in on to my customers.
He has bought my goods and gone.
So
I cannot raise a debit bill on it. So, and that is not the stand of the government also, that we will not pay. They stand, because now your lordships know, this is an administrative order which is made rejecting my claim. So, it has to stand on the basis of the reasons recorded in the order. That cannot be allowed to be supplemented now.
Mohinder Singh Gill.
Mohinder Singh Gill, consistently followed. That is the only ground which they can take, that my rejection was valid. And your lordship sees, if I may, with the greatest of respect, see the male stand of the state. Today, my lord, after your lordships have held that the licensee has already certified, kindly see the order passed by the writ court at the first instance, please, my lord. Kindly see the order once, please, my lord. All these issues were not in rest. They were no longer res integra, but yet they go and reject my. Kindly see page 179, 175, please, my lord. The order of 2nd of, this is 2nd February 2018. This is at the first instance when they were not making
170?
175 of the stay, please, my lord. This is in the first writ. How, my lord, the person who has invested is being harassed, my lord. Kindly see, my lord. The officer in charge, may I please, my lord. The officer in charge, sub-district so-and-so Siliguri, hereinafter the officer in charge, by his letter dated so-and-so, requested the Chief Engineer Commercial State Electricity Distribution Company to confirm, this is the letter which I showed your lordships, my lord, to confirm whether the energy charges as detailed therein were paid to the licensee by the petitioners or not. That is the letter which I showed your lordships. Such confirmation was requested in view of an approach having been made by the petitioner to such officer in charge for subsidy on the electricity energy charges paid as per the revised claim of energy charges due to redetermination of tariff by the Regulatory Commission under the scheme of 2007. Now, can you see the next paragraph? Very important. Upon receipt of such letter, the senior manager of the licensee confirmed that the petitioners had indeed made payment of the energy bills for these years as reflected in the enclosed document. This is a finding of court on fact, which is not assailed. The grievance of the petitioners is that till date the subsidy to which they are entitled has not been released by the said so-and-so. Accordingly, a direction has been prayed. Now, can you see 176? Having heard Mr. So-and-so learned senior advocate for the petitioners, Ms. So-and-so learned advocate, as his ladyship then was, for the licensee, and Ms. So-and-so and Mr. So-and-so learned advocate for the respondent number 7, I find no reason to keep the writ petition pending. The petitioners are granted liberty to submit a representation before the respondent number 7, that is the state, within a fortnight from date, enclosing all relevant documents in support of their claim. Once such representation is received, respondent number 7 shall not waste any time to consider dispose of the same. Needless to say, if the claim of the petitioners is rejected, the same must be supported by reasons. They have a month's time from date for receipt to dispose of the petition. No opinion is expressed. Petition stands disposed of. So, my lord, one further chance was given to the state after recording that the licensee has confirmed. Now, my lord, kindly see what the state does. I gave them all these documents. Now, kindly see the order of the state, please, my lord. 15th March 2018 at page 181. Page 1, my lord, records the facts which are, I need not trouble your lordship with, my lord, the narration of facts. Kindly come to the next page, my lord. Kindly see the third paragraph after recording clause 10.3. Since the petitioner company, your lordships have that. Since the petitioner company has not submitted any money receipt or documents in support of such payment of area energy charges, this office issued a letter, vide memo number so-and-so, dated so-and-so, to the chief engineer commercial of the licensee asking for confirmation of payment if made in so-and-so. The licensee only mentioning about any enclosure of detailed statement of area energy charges paid, charged by licensee to the petitioner company in the energy bills for so-and-so, but with no confirmation about any payment, if any, made by the petitioner company. The lordships have already held in that order that the licensee has confirmed payment has been made. Then during hearing, this office has inquired to the petitioners about the documents, if any, belong to them, proving substantial payment made. from their end energy charges as demanded by licensee. In contrary, the petitioner showed different bills of the licensee but could not produce, now my lord kindly see, any money receipt against such area energy charges. From the bills of the licensee, it is not ascertained about payment, if any, made about energy. On the ground, now my lord kindly see, on the ground of non-production of money receipts against payment, which is mandatory as per clause 10.3 of the scheme made from their end towards such energy charges during submission of representation dated so-and-so, made by so-and-so the director, as well as in hearing in support of their claim for subsidy, their claim is hereby rejected. So they say, my lord, that the claim is rejected because it is mandatory to produce the money receipts in terms of clause 10.3. And your lordship will kindly take the trouble of coming back to 10.3 once, please, my lord. It was placed before your lordship earlier. I'm sorry to trouble your lordships again. Kindly see page 60, my lord. It doesn't say it is mandatory. Kindly come to page 60, please, my lord.
No, even if it is mandatory, then also the onus has been discharged.
It is for them to say this has not been paid. This is not like a burden of proof in a suit for declaration of title that the onus never shifts.
Okay, you have got.
And my lord, these monies are due since 2012, my lord. Your lordship has seen the period.
Mr. Bormon?
This is the only reason. Now they cannot agitate anything else, my lord.
Anything further?
Actually, our plain and simple case is that this is not a source of earning any profit. This is policy of only to give subsidy to encourage, which I have stated earlier. As per the scheme, as per the clause 10.3, they are entitled to this subsidy strictly for a period of 5 years.
No,
So
absolutely correct.
And the subsidy will be on the electric grid, not on any area or.
No.
It is plainly speaks that eligible to waiver electricity charges.
Electricity charges.
There is no single water has been used. If there is any, that is between the board and distribution company and the petitioner. There is not a single what has been used that in case of any area, in case of any charge revision, we are entitled. The plain clause says that we will pay this and this at the rate of 40% upon the electric charges for period of 5 years.
The argument which you are now advancing is not reflected from the order of the authority concerned. The authority concerned procedure that
no, they have written that whether this has that was another point. Whether you confirm whether the charges has been paid. Subsequent for the subsequent, the department has never admitted that we are going to pay.
See, before the pursuant to the order of Justice Doctor, as his lordship then was, you were required to, the authority was required to consider the case in the light of the discussions made there. Now, in the reasoned order, which is the product of the hearing pursuant to the said order, the point is that the receipts have not been shown. There you have not said.
That was
there you have not said.
They were more concentrating upon the receipt.
Sorry. Take down.
But we have
take down.
They had formally said, and this is not a ground taken in the appeal also.
No. First ground is that
okay, taken, it is not accepted.
May I cite the Mohinder Singh Gill
formally?
I'll leave like I don't want to burden that.
You give the citation 78 Supreme Court.
Yes, I've got a
78 to SCC probably. Yes.
I don't mind. Kindly Mohinder Singh. I've got a 78 1 SCC 405.
So the liquor of
78
1
SCC 405. You give away one.
But I've got a subsequent judgment of 2016 which refers to this. Mohinder Singh Gill. My learned friend, my colleague did not take a printout of Mohinder Singh Gill because it runs into 70 pages. So he found us.
And that particular thing
paragraph 8 at the beginning.
Only one small paragraph.
Yeah. Here, my lord, paragraph 4, where Mohinder Singh Gill is followed, my lord, at page 727.
Before Lordship takes over, and so far their appeal is concerned, so far interest there is no scope because
আমার appeal টা আগে হয়নি আর স্যার আপনারটাই হচ্ছে
তাহলে দুটো তো একসাথে
Yes, what do you say?
So for this is a scheme, benevolent scheme, not any source of any earning profit. So if
No, no,
lordship allows
you are thinking if interest is
Yes.
awarded, that would be
burden upon the state.
See, this is only in respect of, so far as I know, regarding the advocates. If the client pays you after 5 years, they will be paying you the bill amount, nothing excess. But in all other commercial transaction or other, you see, if you consider the doctor, you immediately you come out, his man will be there to collect the fees.
Even before
That document on which they give the prescription, letter pad is not issued for the doctor to give. The first you pay, then you take the blank letterhead, then you go, then he will write the prescription. That is not the new practice.
No,
So
there is a judgment of the Supreme Court as well as the jurisdiction. Interest is not to allow any person to earn profit.
Yes.
Or it is not a punishment.
I'm carrying.
If you withhold the money of others, the money will there will normal acquisition. You cannot deny. If that person would keep that amount in bank.
contract, এটা একদম basic principle of contract. The money was with you, you have derived benefit of out of
That's
it.
it.
Because if you had paid him at that juncture, then you could not have you could not have benefited. You could have deposit of section 144 of CPC restitution. These cases were regularly happening under the 1940 Act. Because 1940 Act judgment on award. That was the award on being filed was converted into a decree. Now, to avoid additional interest, the award sufferer such ground does not persuade us to hold a contrary view to that expressed by the learned single judge in the order in. Clause 10.3 of the said scheme yes clearly speaks of reimbursement of electricity charges. Full stop. The revision with the revision of rate of electricity, which is made, a revision of electricity made by WBSEDCL.
Rate of electricity made by
WBSEDCL and made applicable
rate of the division of rate of electricity made by WBSEDCL.
which became operative retrospectively is the electricity charges referred to in clause 10.3 of the said. The full stop. Northeast, therefore, retrospectively, Northeast had to pay the said charges retrospectively. Pay the additional charges. Northeast
had to pay the
additional charges on retrospective revision.
Northeast had to pay the
additional charges for the period between 1st April 2007 and 31st March 2012. Both though retrospectively made applicable, but for the said period.
As if the earlier was not at all.
Yes.
The period when for which I was entitled to incentive on the date of the commencement of production.
Yes.
Which is for 9 November 2009, 8th November 2004. It's like 5 years.
9th November. But the scheme was
established sort of later on.
No.
QE is of 2007.
No, but
5 years from the date of commercial production. That's the eligibility.
no, Mr. Thakkar, there I have to point it out. I read. See, no.
Say pay the initial charges also.
No. If you come to the scheme, commencement and duration,
Yes.
first day of April in the whole of West Bengal and shall remain in force for a period of 5 years ending on 31st March 2012. So there must be some notification to make it applicable for 5 years beyond 2012.
10.3 months period. So all units which are established within this period of 5 years, when the scheme is valid, now the incentive will run for a period of 5 years from the date of commencement.
Very well. কি বললাম ওটা দাও? হ্যাঁ।
Notice had to pay the additional charges for the period between 1st April 2007.
No. Between 8th November.
9th November.
The additional charge.
No.
9th November 2009 to.
The additional charge is from May 2010 to November 2014. That is the period of the additional charge.
কি বললাম?
Notice had to pay the additional charges for the period between
May
2010
to
November 2014.
November 2014. Full stop.
That's for the
Northeast having been Northeast having set up Northeast having commenced its commercial production within the period of 1st April 2007 and 31st March.
It is given as financial year 2010, 11, 11, 12, 12, 13, 14, 15. At page 170.
Very well.
There is no specific date.
কি বললাম তবে?
Northeast having commenced its commercial production
On 9th November
2009.
That is within the period between 1st April 2007 to 31st March 2012 was entitled to the subsidy for a period of 5 years from the date of commencement of its commercial production. The time period for which the additional amount was realized due to retrospective revision of electricity charges also fell within the 5 years period for which Northeast was entitled to the subsidy. We therefore have no doubt to hold that Northeast was entitled to the subsidy for the additional amount it had paid on account of revision of rate of electricity, which was made applicable retrospective for the period 2000 দেখো ইয়ে থেকে
May 2010
হ্যাঁ মে 2010 to
to November 2014.
2004. We therefore do not find na full stop. Furthermore, the refusal to allow the subsidy for the additional sum was on the ground of non-production of payment receipts by Northeast. In support of payments made by it for the revised electricity for the additional amount to WBSEDCL on the retrospective revision of rates. Full stop. This ground also does not hold good, particularly in view of the admitted fact recorded in the order dated 2nd February 2018, which is set out herein above and had remained unassailed. That apart, and in any event, the licensee, bracket WBSEDCL, in all stages have confirmed receipt of payment of the additional amount on retrospective revision of rate from Northeast. We therefore do not find any cogent ground for refusing the subsidy with regard to the additional amount of electricity charges paid by Northeast on retrospective revision of rate of electricity charges made by WBSEDC. We have also considered the order of the learned single judge being the order impugned in the light of the arguments advanced and discussion made herein above. We do not find any infirmity in the order as urged by the directorate. ওর পঙ্কজের কাছে পুরোটা দেয়া আছে by the directorate. By the directorate. The appeal being MAT 1 of 2020 preferred by the directorate, therefore stands dismissed. Dismissed. In respect of the appeal preferred by Northeast being MAT 73 of 2024, we find that the learned judge, after
considering all aspect of the matter, allowed the principal sum of rupees
You core 50,000, 50 lakhs. If you core 50 lakhs, 37,115.
but did not award any interest. Under the common law, or under the common law concept, the directorate, on having not paid the principal sum in time, had retained the said sum of rupees so and so with it, thereby deriving benefit out of the same. On the other hand, Northeast, having been deprived of the said sum, is Northeast, having not been paid the said sum of rupees, failed to derive benefit out of the same, which it could have done in ordinary course had it received the money in time. Northeast has also relied upon a judgment reported in 2024 SCC Online SC 559, wherein the interest aspect has been considered in details. We have no reasons to deviate from the ratio so laid down. In the facts of the instant case and in the light of the discussion aforesaid. Since the directorate derived benefit out of the said sum of rupees or two and Northeast was prevented from the benefit of such sum of money. The directorate is required to compensate Northeast for the same. The compensation is in the form of interest. In the aforesaid facts and circumstances, when was the initial payment?
It was due from 12/13, but they have themselves sought, I'm not going to 12/13, they sought confirmation of accounts on 17 June 2050. By that time, everything, they have processed the claim, they only sought confirmation from the licensee. which they received my lord on 29 June 2050. At least from 2050 because of the
No, when did you pay the last installment of the revised amount?
last. Yes, so that was only in the sum of 99. The last installment, the installment payments were for only on the amount of 99 lakhs, which was on the last revision. Full amount madam was 6 crores 29 lakhs. The entire revision period over the 4 years was 6 crores 29 lakhs.
The 2.58 is the 30% as per the scheme.
Yes.
So that is,
And the last installment payment was only of 99 lakhs. 99 lakhs, the earlier amount was already paid. Installment was given of 99 lakhs, which was in 48 installments from 2030. But the letter, their letter records all this and says this amount is the 5 crore 30 lakh has been paid already. Only the 99 lakh amount, which was the last revision order, was paid over 48 installments. Well, from 2015, your lordships will kindly consider. Because that is the date when they assess the
Mr. Thakkar, you take it from the last date of the installment. Because otherwise, for this reason, you may.
They are very belligerent, they will lie over where this matter will be. They also can consider this. 5 crores 30 lakhs was paid in 2012-13 itself. Only the 99 lakh amount was paid in installment. Majority was already paid. No. December 16, your lordship.
Page 68.
That is the last date. Last installment is December.
January
17. In the appropriate facts and circumstances.
Aforesaid circumstances, the Northeast is entitled to receive interest from 1st January 2017 on having paid the last installment for the additional sum in December 2016.
As confirmed by the
as appears from the record, which is not disputed by the directorate. In the aforesaid facts and circumstances, we direct the directorate of VA to pay interest on rupees 25 VA. 58 lakhs. 2 crore 58 lakhs something.
2 crores 50 lakhs. 2 crores 50 lakhs 37,100.
ওটা লিখে রাখো, ভুল করো না স্যার। হ্যাঁ, ঠিক আছে।
To pay interest of rupees
on rupees at the rate of 8%. At the rate of 8% per annum.
Supreme Court 12% given compounded.
Banking interest is 3 point something.
No,
Yes.
that is absolutely incorrect. Kindly see this section 34 of the Civil Procedure Code. Your lordship knows better than me. Lending rate was 15%. Kindly see. Kindly see.
But you the availed of that opportunity to pay the amount by installment.
No. See, Mr. Thakkar.
I have out of pocket, but 18% interest I paid to the banks. So that is recorded in my letter. But I am paying interest at 18%. Please give me this money. And your lordship is 12% compounded.
You won't be able to sustain.
12% compounded. Can you see the Supreme Court? Supreme Court is awarding. Saying 25% I would have given, but this is public money. It's entirely discretionary. But now section 34, your lordship knows, has been amended.
35A.
Yes. Compounded in commercial, these kind of things, it is can get any amount. And the, I'm sorry, not any amount, the lending rate of the bank is to be considered.
PLR.
PLR. Well, can you see State Bank of India PLR then in January 2017 was 15%.
কি বললাম?
12%
per annum until repayment. We find that the rate of interest allowed is reasonable and fair, considering that the amount is receivable under an incentive scheme and is not directly interlinked into a commercial transaction. Though Northeast may have to pay at higher rate of interest in respect of any financial assistance it had availed for its commercial activities.
I'm not arguing, but I am not, Lordship sir, I'm not, there's no cross exception in the offering method. Can we see the contact for since 2012, 1 year straight, first order of the writ put down, this is the third round of litigation. The cost of the litigation have also have been much more than this interest.
ঠিক আছে, ওটাকে 9%.
Can we compound it?
No compound. 9% করেছে। No, see, he's correct. We have not awarded any cost. Otherwise, we would have awarded you a heavy cost.
Cost should have been imposed.
ওটা এমএটি উইথ হচ্ছে ওই কানেক্টেড অ্যাপ্লিকেশন, এটা হচ্ছে এমএটি উইথ কানেক্টেড অ্যাপ্লিকেশন।
Provide a time frame within which the
Yes. The interest as directed to be paid shall be paid within a period of 12 weeks from the date of communication of this order.
interest and principal is also not. Principal
আচ্ছা।
interest
এখানে ইয়েটা আছে তো ওখানে দিয়ে দাও, সরি কি বললাম? No, I missed out. The principal sum of such and such 2 কোটি। তোমারও আমার মতো অবস্থা। Yes, it will be taken care of. Has also not been paid. Has not been paid by the directorate to Northeast as directed by the order impugned, since the directorate has assailed the same in MAT number such and such. We have dismissed the said appeal along with all connected applications. Said appeal MAT হচ্ছে 1 of 2020 and as such Northeast has become entitled to receive the principal sum of rupees such and such. The principal sum of rupees such and such, along with interest at the rate of 9% per annum,
till the date of repayment shall be till the date of till the date of shall be paid within a period of 12 weeks from the date of communication of this order. So it is also made clear that in case of default, the interest rate will stand increase to 12% per annum. ঠিক আছে? Nothing further remains. See, when you go for the tax, the rebate is gone because you have not paid within this time. Then penalties accrue because there was a delay. All these things, I will not name the judge concerned, but in a similar situation, tax, it was said that when you come for income tax, if the the advance tax does not meet the amount, you are required to pay the interest and penalty. Then why should you be forgiven for the same?
Sometimes on daily basis.
Baba, বিচ্ছিরি ব্যাপার।
High rate of interest, putative interest, sir, 2% or something, 1.5% for one month.
Yes. চলো উঠে পড়ি, কটা 4:30 বেজে গেল। চলো।